All right, good morning, everyone. It is 8:08 a.m., October 18th, 2024. This meeting will be open to the public at the above location and will proceed by video conference as allowed under Texas Government Code Section 155.127. The location above shall have two-way audio-video communication with each of the other locations during the meeting. The president or presiding officer of the board will be physically present at the location and room listed above. Please note that accommodation will be available for members of the public to physically attend the meeting at the above location, but will be subject to limitations set out by the Texas Facilities Commission seating. Members of the public are encouraged to attend the meeting by accessing the video conference or audio link below. I now call the Texas Medical Board meeting to order, and we can have roll call.
Dr. Zaffron.
Present.
Dr. Farmer.
Here.
Mr. Kokonos.
Present.
Ms. Barnes.
Present.
Dr. Bhatia. Didn't see, is he frozen? Didn't hear you yet, Dr. Bhatia.
I'm present.
There we go. Thank you. Mr. Crane.
Present.
Dr. Deloche.
Here.
Mrs. Del Rosal.
Present.
Dr. DeStefano.
Present.
Mrs. Harrod. Yeah. Dr. Jones.
Here.
Dr. Martinez.
Here.
Mrs. Morgan.
Here.
Dr. Naidu. Dr. Nyack. Dr. Quinones.
Present.
Dr. Tibbles.
Here.
Mrs. Troncoso.
Here.
Dr. Vanderwide.
Yes, sir.
All right, we have a quorum and may proceed.
Great, thank you. So first, we always, of course, start with talking about what the mission statement is of the medical board. Our mission is to protect and enhance the public's health, safety, and welfare by establishing and maintaining standards of excellence used in regulating the practice of medicine and ensuring quality health care for the citizens of Texas through licensure, discipline, and education. The first item on the agenda is the board member report, and there's a couple of items that I wanted to highlight today. First is, we wanted to honor Robert Gracia, who's going to be coming off the board, and we have a resolution here in his honor. I'm going to read this resolution out loud. Whereas the members of the Texas Medical Board wish to express their appreciation to Robert Gracia for his outstanding service on this board from April 17th, 2018 to August 19th, 2024. And whereas he gave unselfishly of his time and energy while serving on the board, and whereas he demonstrated compassion and professionalism while seeking to ensure quality health care for the citizens of Texas, and whereas his intellectual ability, personal strength, and deep commitment to the ideals of public service are unexcelled, and whereas he was an invaluable and enthusiastic member of the board and contributed his time, including serving on the licensure committee, now be it resolved that the members of the Texas Medical Board join together to honor Robert Gracia for his service, and further that a copy of this resolution be tendered to Mr. Gracia and that it forthwith be inscribed upon the permanent minutes of the board. So, Mr. Gracia, we would like to honor your presence and thank you for your service. And here's a virtual clap to you. It's too bad that we've had the last couple of years where we haven't been present all together all the time to where we could do this in person. But really, once again, thank you for your service. It's been an honor working with you. With that, we've also have several new members who are on board and today here for the first time. I'd like to highlight who they are. First is Gary Crane. Gary Crane of San Marcos is a retired healthcare administrator with over 3 decades of experience. He's the former vice chair of the Texas State University System Board of Regents and former member of the Johnson County Chamber of Commerce, Murray State University School of Nursing and Health Professions Advisory Committee, and the Johnson County Memorial Hospital Board. He was named the first distinguished alumnus of the University of Oklahoma Hudson College of Public Health, Crane received a Bachelor of Arts in Political Science from the Texas State University and a Master of Health Administration from the University of Oklahoma Health Sciences Center. That may be the only negative thing that we have here on him.
Boomer sooner.
That Oklahoma State stuff, that Oklahoma stuff also.
I'll be
Now,
in Stillwater.
Yeah, we heard a lot of Boomer Sooner stuff last Saturday, but that quieted very quickly by halftime. So anyway, Zachary Jones, MD. Zach Jones, MD of Frisco, is a board-certified anesthesiologist with Metropolitan Anesthesia Consultants. He's a member of the Texas Medical Association, Dallas County Medical Society, American Society of Anesthesiologists, and the Texas Society of Anesthesiologists. Jones received a Bachelor of Arts in Biology from the University of Texas, UT at Austin, and a Doctor of Medicine from UT Health Science Center in Houston. Luisa Del Rosal of Dallas is an entrepreneur and owner of Everline Coatings Fort Worth Metroplex. Additionally, she's a contributing columnist for the Dallas Morning News and is the Colin Powell Teaching Fellow and Special Advisor for the Southern Methodist University John Goodwin Tower Center for Public Policy and International Affairs. She's chair of the Communities in Schools Dallas and founding member of the Texas Latino Jewish Leadership Council. De Rosal received a Bachelor of Science in Political Science and a Master of Higher Education Policy and Leadership from SMU. Linda Troncoso of El Paso is the president of TRE and Associates, LLC. She's a member of the El Paso Association of Builders and Paso del Norte Community Foundation and former member of the City of El Paso Zoning Board of Adjustments. Troncoso received a Bachelor of Science in Civil Engineering and a Master of Engineering in Environmental Engineering from UT El Paso. We'd love to welcome all of you on board. Yes, it's a virtual clap to all of you, and we will hopefully see all of you in person soon in March. I know that all of you have started the process yesterday on either the licensure committee and the DPRC. So you've already started your work, and very happy to have you working with us today here on the board. So a couple of other things. I'm just going to give a quick legislative update. We had testimony before the Senate Health and Human Services Committee in mid-September regarding access to health care. Coming off the heels of this legislative hearing, and as we prepare for the next legislative session, and as we're welcoming several new board members, this was a good time to remind everyone of what is expected of the agency during the legislative session. Our role is to provide subject matter expertise to lawmakers. We are not there to advocate for one policy or the other, but we are there to offer advice and to answer questions as to how any type of legislative material might impact the board. We are also there to offer the testimony as to what the board's needs are financially, especially as there are proposed legislation that is offered to guide what the board's requirements are, as we are there to protect the public. That means that we also serve as resource witnesses on bills at legislative hearings. We review legislation and raise any implementation concerns we may have. And when asked, we assist members with crafting legislation so that the end product achieves their goals without negatively impacting agency operations. Again, as a state agency, we cannot support or oppose any particular policy. We must remain neutral. Our primary responsibility is to identify implementation of challenges and hopefully work with members to resolve them. As many of you saw in some of the last legislative bills that have passed, again, our role is to, number one, implement those laws, but also to write the rules that govern those laws that have passed. I know that many have thought and attempted to guide us into writing rules that may have extended legislative lawmaking into something beyond what was intended. And as I've mentioned many, many times, we cannot do that. All we can do is we can interpret and help guide and write rules around the laws as they have been written, but we cannot go beyond what legislative intent is and what the letter of the law is. And this is just another opportunity to remember and highlight what the limitations of what we can or what we can't do are. Another item I was going to go over is our enforcement process review. The medical board is a complaint-driven agency. We are unable to open and conduct investigations on hearsay alone. I know that many have asked us why or why not have we opened investigations on certain matters or certain issues. We cannot do that. Now, there have been instances, and again, Dr. Death has been an example of that, where if it's just hearsay, on that alone, we cannot do anything and we cannot actually initiate an investigation. But, however, just like we have in other instances, when we do get enough information, and if there is enough interest, even if there not necessarily has been a complaint filed, then I myself, in some instances, can ask for an investigation to be started. Things like that may have included something that has come up in the news, where we know that somebody might have been arrested for a reason that we know would clearly violate the Medical Practice Act. We've seen that in several instances in the past 6 months. In instances like that, we can initiate an investigation and not necessarily wait for a formal complaint to come in. But for the most part, we are a complaint-driven agency, and we do want members of the public or licensees or anyone to file a complaint if they know that there is a concern about a violation of the Medical Practice Act. Now, we do need to receive a complaint that answers the who, what, where, and when questions. This includes patient and licensee names, date of incident and address, etc. If we do not have a complaint or the complaint lacks enough specific information, we cannot investigate. Now, again, there are some instances and circumstances where if there's a concern that somebody may be practicing medicine without a license, even though there may not be specific patient complaints or a complaint against a physician with a specific patient there, but we would need in those instances examples of false advertising or other specifics that would help guide our investigation. Now, the other thing I was going to talk about, and we mentioned this a little bit yesterday when we talked about our board meeting process review. For example, recusals is a key thing that I just want to make sure that we highlight. We do want to avoid conflicts of interest. If a conflict of interest should unintentionally occur, the board member should recuse himself or herself from participating in any matter before the board that could be affected by the conflict. Also, remember that all information is confidential information. Please refrain from using licensee names when conducting board business in a public forum. All of you know that you have those file numbers, and that is what we will typically go by. The only exception to that is for example, the PFDs that you will see conducted here today. The information in the licensure applicant's file is confidential. The information presented to the licensure committee when an applicant appears before them is also confidential. The information in the investigative and disciplinary files being reviewed are confidential. Information presented to the DPRC when a complainant appears during an appeal is also confidential. The only final thing that I'll talk about is committee membership. Most of you, well, all of you, are either on the DPRC committee and on the licensure committee. Our new board members were voluntold as to which committee you're going to be on. But we also always offer an opportunity for those of you who have been on one committee for a lengthy period of time, the option to ask if you would like to serve on the other committee. Now, there does need to be equal numbers on both committees. So if we were to get some members on the DPRC committee who would like to leave early on Thursday on a regular basis and go to the licensure committee, there would need to be somebody on the licensure committee who would love to just stay a lot later and finish, although we finished yesterday before 3 o'clock, and join us on this side of the ledger. So again, just let us know if you have that interest. And again, there has to be an equal number, or at least some who on either side who would like to move. So just let me or let Brent know, and we can go through that process if need be. I think that's the highlight of my report. Some other things that I would be talking about, actually, Brent will be talking about in his report, which kind of brings me back to the last thing I'm going to mention, which is welcoming Brent back. Brent has been gone for 6 months, serving our country on the other side of the world, and he actually got back into Austin Wednesday night and jumped right into our meetings Thursday morning. So not a day has let by, but I also will tell you that on that other side of the world, where there's about a 9 or 10 hour difference in time, Brent would be opening his computer or opening his phones to actually starting to conduct board business. So there was no let up in managing the board while he was gone. He would do his duties during the daytime over there, and he would do his board duties in the evening over there, which was daytime over here. So I don't think that any of us missed a beat. I know that the staff and also us as board members appreciate his service to the country and are glad to have him back just in time for the UT Georgia game. So so that we can cheer our team on. So again, welcome back, Brent. All right, with that, I am going to go to the next item on our agenda, which is consideration and possible action for dispositions below minimum guidelines. There is one item there on that agenda. Are there any extractions or recusals on that item? Seeing none, I will entertain a motion for item number 3.
Yes, sir. I move that we accept the recommendation for the acceptance of the first item there.
So we have a
Second,
motion from Ms. Barnes. Is there a second?
I'll
Second,
second it,
Quinones.
Dr. Farmer.
Okay, seconded by Dr. Farmer and Dr.
Thank you.
Quinones. Is there any further discussion? All those in favor, please say aye.
Aye.
All those opposed? All right, item number 3
Thank you.
passes. Item number 4, consideration and approval of mediated settlement agreed orders. Are there any extractions or recusals on item number 4? Seeing none, is there a motion on item number 4?
Motion to accept consideration and approved mediated settlement agreed orders. Quinones.
So a motion by Dr. Quinones and seconded by Dr. Vanderwide. Is there any discussion on item number 4? Seeing none, all those in favor, please say aye.
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 All those opposed? All right, item number 4 passes. Item number 5 is consideration and possible action for remedial plans. And under there, you see administrative rules, under crime laws that are none, under impairments that are none, there is peer review state action, there is standard of care, which has quite a few, and you have unprofessional conduct, and then there are late orders, which there are none. Are there any extractions on any of the items under agenda item number 5, or are there any recusals under the agenda item number 5?
Dr. Quinones, recusal on item number 21.
Okay, Dr. Quinones is recusing on item 21. Are there any others?
Dr. Martinez, recusal on number 17, Eckrotar.
Dr. Martinez recusal on item number 17. Any others?
Bhatia, recusal number 34.
Okay, Dr. Bhatia recusal on item number 34. Any others? All right, and again, are there any extractions on agenda item number 5? Just want to make sure since it's a lengthy agenda item. All right, seeing none, is there a motion on agenda item number 5?
I'll make a motion to approve the items under agenda number 5.
Second, Tibbles.
Okay, there's a motion by Ms. Morgan and a second by Dr. Tibbles. And with the exception, well, is there any further discussion? All right, so with the exception of Dr. Martinez recusing on 17, and Dr. Quinones recusing on 21, and Dr. Bhatia recusing on 34, all those in favor, please say aye.
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 All those opposed? All right, agenda item number 5 passes. All right, agenda item number 6, consideration and possible action for agreed orders. Under administrative rules that are none, you have crime laws, impairments, peer review, state action, standard of care, unprofessional conduct, and late orders. Are there any recusals or extractions on agenda item number 6?
Quinones, recusal on item number 10.
Okay, Dr. Quinones recusal on item number 10. Are there any others? All right, and no extractions? All right, seeing none, I will entertain a motion for agenda item number 6.
Vanderwide, move to approve the acceptance of agreed orders under number 6.
Second, Barnes.
Okay, we have a motion and a second. Is there any further discussion on agenda item number 6? All right, seeing none, with the exception of the recusal on item number 10 with Dr. Quinones, all those in favor, please say aye.
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 All those opposed, say nay. Agenda item number 6 passes. All right, agenda item number 7, consideration and approval of modification requests and termination request orders. There are several items under there. Are there any recusals or extractions on agenda item number 7? All right, seeing none, is there a motion on agenda item number 7?
Quinones, move to accept the modification request, termination request orders listed in item number 7.
All right.
Second.
Motion by Dr. Quinones and a second by Dr. Farmer. Is there any further discussion on agenda item number 7? All right, seeing none, all those in favor, please say aye.
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 All those opposed? Agenda item number 7 passes. Agenda item number 8, consideration approval of modification request, termination request of non-public rehabilitation orders. There are none there. Number 9, consideration and approval of cease and desist orders. Is there any recusals or extractions on agenda item number 9? Seeing none, is there a motion on agenda item number 9?
Move to
Motion to
approve.
accept, Stefano. Or second to
So-
Stefano.
So motion by Bhatia and second by Stefano. Is there any further discussion on agenda item number 9? Seeing none, all those in favor, please say aye.
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 All those opposed? Agenda item number 9 passes. Number 10, consideration and approval of non-pro-tunc orders. There are none. 11, consideration and approval of agreed resolution orders. There are none. Number 12, consideration and approval of consent orders. There are none. And number 13, consideration and approval of determination of default. There are none. That brings us to agenda item number 14, which is consideration and approval of proposal for decision. Now, for those of you who are new here, there's a lot of nuances to a proposal for decision. So I'm actually going to let either Brent or Scott, our general counsel, go through the process of what we can or what we can't do and what exactly a proposal for decision is, because there's some very specific nuances to it, and there's a process that we're going to go through with it. So with that, I'll hand it off to you, Brent.
Thank you, Dr. Zaffron. Yep, for our new board members that may not be familiar with this quite yet, a proposal for decision comes from the State Office of Administrative Hearings and is issued by an administrative law judge. So as we go through the investigative and disciplinary process for the board, there will be a step that comes before going to SOA and the informal settlement conference. And at that time, the licensee and their counsel, if they have it, would come before a panel of the board and have a chance to kind of talk about the allegations and what's happened. If they're unable to settle it at that point in time, then the board may file with the State Office of Administrative Hearings. It would go before that ALJ as an outside party to hear the case. At the conclusion of that, the administrative law judge will issue what is a proposal for decision. It has findings of fact and conclusions of law. And then that comes back before the entire board here today, at which time there's a little bit of a few more things to go through. The board staff will present it's kind of a summary of the case and present what the board staff is asking the board to do as far as a decision. And the licensee and their counsel will also have an opportunity to speak to the board, present any type of mitigating factors or whatever they may have to talk about the case. It still has to be something that's confined to what happened. Can't be anything that's outside of what was in the record and what happened at SOA. But ultimately, then the board will have a chance to discuss what to do. If they need to, they can go into executive session where to be closed to the public if they need additional input from counsel, from general counsel. So that's kind of a real quick overview of what is about to happen here. Each side is going to get 10 minutes. Board staff goes first. They have a total of 10 minutes. If they only use 7, perhaps, then they can kind of reserve the remaining 3 minutes as a rebuttal at the end. Scott, is there anything to add before we get started?
Just a couple of things. Yes, Brent. Do know that this is like at the State Office of Administrative Hearings, this is like a trial. There was discovery, there were depositions of witnesses, there was trial testimony, cross-examination of witnesses. So it's a very thorough proceeding. As Mr. Carlton just said, it's now going to be presented to you. The judge, the administrative law judge, makes the findings of fact, the conclusions of law. That's presented to you. But you as the board have the final authority to decide what to do with the case. Do you take discipline? Do you dismiss it? And again, those options will be discussed after the presentation. The thing to know is when you get to the decision itself, the board, you can't change findings of fact or conclusions of law issued by the judge unless you as a board decide to appeal the findings of fact and conclusions of law. If there were that situation, myself, Mr. Carlton, will advise you at that time, but just be aware that you are making the determination on the facts and the conclusions of law that are being presented to you. And as Mr. Carlton said, the case itself is going to be what's in that record. You may hear, and we often hear, counsel come in and they will make presentations and start talking about all kinds of things that were not presented to SOA. Mr. Carlton, myself, the rest of the general counsel staff will remind you before you go into the discussion that those kinds of things weren't in the record, so they wouldn't be considered. But again, we'll give you the guardrails, but the overview by Mr. Carlton just covered everything well. I just wanted those couple of nuances for you to know as you kind of go into this right now. Thank you.
Okay. We have our timer we can put on the screen.
So just so that everybody knows, Ms. Swanholm, who is the agency's lawyer, is here, and the opposing counsel is virtually present, I believe, right?
Yes, sir. I believe that Mr. Lecter is online. And so, Mr. Lecter, if you are there, please go ahead and turn on your video.
And is the physician present?
Hold on, I had to extrapolate myself from the bonds of slavery for the mic and the stuff. And yes, the physician is here. Good morning.
All right, thank you. Good morning. Okay, all right, let's proceed.
All right.
Yeah, if we can get the timer on the screen so everyone can see.
Timer's there.
We can't see it.
Yeah, if it's on the screen, it's not showing up in the boardroom. There we go. Now we can see it. Thank you. All right, Ms. Swanholm, you may proceed.
Thank you. So I will keep my statements brief. First, I want to talk a little bit about what we did to get here. This case involves 6 patients. These are patients that received cosmetic surgery procedures from respondent. The judge found violations of the standard of care for 4 out of those 6 patients and record-keeping violations, significant record-keeping violations for all 5 of those patients. We're not going to talk about patient 6 today because there were no violations found by the judge. We acknowledge that, and thank goodness. So patient 1 and patient 2, respondent treated them in 2020. This is a case that has been a long time in coming. The So a complaint was actually filed in August of 2021, but because of COVID and some delays, the hearing on the merits didn't actually occur until January of 2024, 9 months ago. So with patient 1 and patient 2, patient 1 received a Brazilian butt lift from respondent. The same day as her procedure, she ended up in the hospital, in the ER in critical condition. The judge found that respondent failed to call an ambulance for her and instead allowed her to be transported in a personal vehicle to the ER when she was in critical condition. One of the findings that the judge made on this patient, and I'll read from it, it's finding 114, and 116 and 117 states that respondent's actions endangered patient 1's life and put her at risk for further and more serious complications had her condition deteriorated before she arrived at the ER. For patient 2, respondent performed a mommy makeover. That's a procedure that involves liposuction, an abdominoplasty, and a breast augmentation all in one. For that patient, respondent failed to obtain any informed consent for the breast augmentation and also failed to disclose the risks and benefits of different types of breast implants to that patient. For patient 2, the judge found that respondent had documented it in such a poor manner that it ended up potentially endangering the patient because you could not tell whether or not she received a saline or a silicone implant. Specifically,
I'm going to object. That is outside the record and inflammatory without probative value.
Mr. Lecter,
Yep.
hold on. There's no place for objection. You make a note in your rebuttal, and I will advise the panel accordingly.
all right, so I'll read from Finding of Fact 147. Respondent's medical records for patient 2 are inaccurate and misleading because they contain conflicting information regarding whether saline or silicone implants were used for her breast augmentation. Those are not my words, those are the words of the judge. So for patient 3, 4, and 5, these patients were seen within a very short time period. All 3 of them ended up in the ER post-operatively. Patient 3 and 4, respondent performed the surgery on the same day. For patient 3, she received that mommy makeover. For patient 4, she received a Brazilian butt lift. Now I'll just read from the PFD. Those are the findings of fact that the judge has found for patient 3. Several hours after she was discharged from MIA, patient 3 arrived at St. David's ER seeking treatment for bleeding and weakness. She was admitted and diagnosed with significant hemorrhage from all her incision sites and required blood transfusions while hospitalized. Respondent did not visit patient 3 or otherwise participate in her medical care while she was hospitalized. Patient 3 had a post-operative appointment with respondent the same day she was discharged. Respondent evaluated and documented that she was healing normally and that they had reviewed post-operative instructions, but nothing in respondent's medical records reflected that patient 3 experienced complications or hospitalizations at all. Same thing with patient 4. She ended up in the hospital after her procedure. Respondent had no interactions with her of any significant manner while she was in the hospital and documented in his medical record that everything was perfectly fine post-operatively. For patient 5, I apologize while I get there. Patient 5 received a BBL. She ended up in the hospital post-operatively the same day as surgery. Regarding her care while she was at respondent's facility post-op, this is what the judge found, and I'm starting at Finding of Fact number 92 if you want to follow along. Respondent's medical records reflect in 2 places that patient 5 was medically stable and discharged at 10:20 a.m. from respondent's facility. However, she was not discharged and did not leave MIA Aesthetics for another 5 hours when an ambulance took her to St. David's ER. While EMS records show an ambulance was called at 2:44 p.m., respondent's records do not reflect that anyone at MIA called an ambulance for patient 5. Patient 5 was admitted at St. David's, and ER records show that staff spoke with respondent, but respondent did not document the conversation in his own records. Nothing in respondent's medical records reflect that patient 5 experienced complications or was hospitalized. So this represents a significant pattern here. We have violations of the standard of care for 4 out of the 5 patients and significant medical record keeping violations for 5 of those patients. Now, the judge did find, along with an aggravating factor, that there were multiple patients with multiple violations. The judge also found some mitigating factors. So our proposed sanctions come from a place of acknowledging that there were multiple violations, but also acknowledging that respondent does have some rehabilitative potential. The ordering provisions that staff has recommended are based on the sanction guidelines. These are the same sanction guidelines that your hearings counsel advise you on in ISCs. It's available publicly in the board's rules in the chart. Public reprimand, a restriction to performing surgeries in a licensed hospital facility for all surgeries. The sanction guidelines call for a restriction. Board staff is not recommending a wholesale restriction on any sort of surgery or surgery altogether, but instead the location that the surgery can be performed so that respondent can get some rehabilitative assistance, that he can work with his colleagues when he's performing these surgeries, and to protect the public so that if there are complications where patients need massive amounts of blood transfusions like these patients needed when they went to the ER, they're already in a facility that has the ability to transfuse blood that is needed for those patients. 12 cycles of chart monitoring. This is education, the ability to grow and learn as he's getting those chart monitoring feedback through each round of the chart monitoring. The PACE medical record keeping course, again, education. JP exam, education. CME, directed to some of the issues that were identified as we went through the trial, education. $8,000 administrative penalty. This comes specifically from the sanction guidelines. There are 4 patients, $2,000 each is the minimum. So we've recommended an administrative penalty of $8,000. 2 times 4 is how we got with the $8,000. So at this time, I'll reserve the remainder of my time for rebuttal. Thank you.
Great. Thank you, Ms. Swanholm. Mr. Lecter, are you prepared to proceed?
Yes. Good morning.
Good morning.
Does anybody feel the need to recuse themselves? Just asking. Okay. Well, the last time we spoke, Dr. Zafran, Sharif, you told me, well, if you don't like the offer, go to trial and we'll talk about it afterwards. And here we are. And that was a one-sided reading of the complaint and the findings found about respondent. And I must say, after having done, I don't know, 15,000, 20,000 ISCs over 25 years, this is an egregious abuse of discretion that this order is recognized. Number one, it is outside the matrix. And number two, the findings of fact have been misguided by staff's presentation to the board members as to what they actually mean. I would like you to look at the number of findings of fact that exist and look at the complaint. This complaint alleged a soup to nuts assault against my client, who is now board ineligible because this case took 4 to 5 years to get to a hearing. During that time, my client lost his board eligibility and received a notice, excuse my fax machine, a notice from the American Board of Plastic Surgery that he can no longer sit for the exam and that he must appeal and present his cases. Now, along those lines, we have the statements regarding patient 2 as the basis for the American Board of Plastic Surgery's refusal to allow my client to sit for the board exam was the fact that he was under, quote, investigation by staff, and there was a complaint publicly filed at the State Office of Administrative Hearings. Subsequently, he had to file the entire chart, and included in that was the consent form that Ms. Swanholm says was, quote, represented a serious danger to the patient. It should be noted that not one patient appeared on behalf of staff. 6 patients, 4 years to allow them to get ready and present. 1 patient appeared by deposition. She did not appear pursuant to subpoena and refused to testify. The one patient that didn't appear, which is patient 1, said she had no issues with respondent or the care that he provided her or the manner in which he provided it. And that is what the patient wanted, was a ride to the hospital by her husband, not in an ambulance, which my client said was not a good idea. Yet this is being now advanced to you as something that was egregious and dangerous. If you look at the findings of fact, I don't think it's very hard to determine, why is the judge saying respondent met the care with respect to a Foley catheter? Respondent met the care with respect to documenting fat loss. Respondent met the standard of care with respect to documenting or not documenting what Foley catheter was used for excision from various sites. All these things, all these findings relating to meet the standard of care are based on staff's complaint. So essentially, staff proved that there were some post-documentation errors. And the way we look at this is post-op care is related to continuity of care so that a subsequent treating provider can get their hand around, what's going on with this patient. With respect to patient 3, my client was called by the ER doctor and responded. He was not consulted, so he went to the hospital, but could not enter a note because he was not consulted. And then if you look, there's a subsequent peer review finding or investigation by the hospital where it was dismissed because they found Dr. C met the standard of care, but the documentation was subpar, recognizing that he was not consulted, so he couldn't write into the record. So I don't know, the judge might have been confused. I'm not going to get in their head. But the continuity of care was maintained because the time period for which the patient was hospitalized until they were discharged and met with my client and notes were maintained were consistent within the period of time. So nothing was proven by staff that represented any departure from the standard of care that would significantly harm these patients. These are all potentially known complications, and there's evidence in the record to show that thousands of these operations have been performed. Dr. Sharapov never experienced a patient death, yet his practice has been severely hindered. And moreover, there is no reason why there's this recommendation to not allow him to practice in a quad ASF, but restrict him to a hospital. I mean, the testimony in the record is clear. He cannot obtain hospital privileges until this is cleared up. So if this order is passed, it's not only an abuse of discretion for being outside of the matrix, it's also an abuse of discretion because it essentially ties his hands. I mean, this is a certain person who has gone through a general surgery residency, a hand fellowship, which is microvascular, a burn fellowship, and then a plastic fellowship, plastic surgery fellowship. There is not a patient death. It's been 4 years for staff to try and get its act together. And what we have are minimal findings regarding a lost consent form, which we believe is in the hands of the American Board of Plastic Surgery. The findings, in fact, clearly denote that patient 2's implant sticker, we saw this in the record, is on the operative report. So it's very clear what kind of implant she has. And the notion that this could be misinterpreted or misled and cause subsequent harm by patient 2 is not true. Patient 6, there's no findings. And there are no aggravating factors other than the ones present in here. So when I look at the matrix, this guideline or this recommendation is outside the matrix because there is no ability per the matrix based on first-time violation. And I must say they are minimal. This would arguably represent a CME class, CME course at an ISC, if in general. it says standard of care, more than one patient, prior SOC or care-related violations. That is not the guideline. The guideline of FLIS, and I don't have the page number because I printed it out. But, you know, perhaps it would help Ms. Swanholm to explain where she got that notion that she was able to restrict or recommend a restriction to Dr. Steve's license. Anyway, that's for that. You can look at the matrix yourself. You know, hospitals have peer review and they are private, they are confidential. And the only oversight to the peer review process is you know, the medical board, because you have the ability to look behind the peer review process and say, okay, did this relate to a standard of care violation or did this relate to behavior which could harm the public? So if you condone and agree with this proposed order sent by staff, what the medical board is essentially saying to the public is, yes, go get your trial. Win 120 of 125 allegations and still get sanctioned to a term or a penalty harsher than that which was offered previously. The idea of notion of a trial becomes a joke. And in the court of public opinion, what does that say? You're supposed to overlook a peer review process that's confidential, and you who are in public scrutiny do the same thing the hospital does, which is just overlook the judge's recommendations, overlook the judge's findings. And I ask, you know, have you really read this? Because I hope that you have, but discussions with individuals involved indicate maybe not everybody reads everything closely. If you really read this, this is a CME case and nothing more. This is all post-op error, post-op documentation failure with a patient who is in the hospital where my client wasn't consulted to even make a note in the chart. All of the allegations advanced by staff back in 2001 with
So you have 30 seconds left.
Which led to this complaint. Thank you, Mr. Carlin. Led to this complaint and this onslaught, rendering him board ineligible, not without hospital privileges, really unhinged, unable to do anything. And now, after winning this case, it comes to you to make the right decision. I ask you read it and say, what's the right thing based on 3 post-op standard of care or documentation errors, which per exceptions were deemed standard of care related. And that's it. Not one patient complained. Nothing. And nothing was substantiated.
Thank you, Mr. Lecter.
What we acknowledge. Thank you, Mr. Carlton.
Thank you. Ms. Swanholm?
Sure. So the judge didn't just find standard of care. They also found negligence. They found that respondent did not act in a diligent manner and that respondent failed to safeguard against potential complications for multiple patients. These are significant. The language that I was quoting was language found by the judge in the findings of fact. That's unchanged. We don't have the ability to change that either way. I respect Mr. Lecter greatly. He has to put on a case for his client. But the judge has already decided the majority of these issues. The only thing in front of you is what sanctions are appropriate. Now, thank goodness that we didn't find everything that we alleged, because if we had, we probably would have made some wrong choices early on in the litigation of this case. The judge did find that generally the procedure seemed to be okay, that it was well documented, but that postoperatively things were not done correctly. If you look at patient 3, 4, and 5 together, you see that respondent appeared to have hidden what actually happened with these patients after the surgery in his medical records. Patient 5, which was she was sent to the hospital, or she went to the hospital on her own accord after the procedure did not go well for her. 5 was sent to the hospital. Sorry, there's a lot of patients that went to the hospital. But patient 5, respondent tried to hide in his medical records what was going on with that patient postoperatively. She was crashing, but the records say that she was fine until she appears in the hospital when there's no documentation that she was sent to the hospital. So yes, a lot of the findings are about documentation, but it's what that documentation is about. And it's
Mr. Fresho, I know
finding-
you said I had no right to object, but she needs to point to the record to show the truth in that.
We'll
That is just
handle the-
heinous.
Mr.
Thank you.
Lecter, we will point to the record if the board members have questions.
All right, 31 seconds left.
So that is where board staff came from when they were proposing their sanctions. I'm available for questions and happy to take any questions that you have on our specific recommendations. Thank you.
Okay, thank you both, Amy, Ms. Swanholm, and Mr. Lecter. So just kind of going along what Mr. Lecter's asking, where in the record, if you could point to the record where that was said, just for completeness sake.
So that is in finding, I believe it's in the 90s. Sorry, let me get there. So if you look at finding of fact number 92, and this was for patient 5 who did go directly to the ER from respondent's facility, and I apologize for my misspeaking on that. 92 states, quote, respondent's medical records reflect in 2 places that patient 5 was medically stable and discharged at 10:20 a.m. However, she wasn't discharged and didn't leave the facility for another 5 hours when an ambulance took her to St. David's ER.
Okay. This is now the opportunity for board members to ask any questions of either board staff or of respondent's attorney. So if there's any questions for Ms. Swanholm or for Mr. Lecter, please either raise your hand or just go ahead and ask. And this is only board members now.
Dr. Zaffron, Dr. Tibbles does have his hand up, I believe.
Okay. All right. Dr. Tibbles?
Yeah, one question on finding of fact 92 that you just pointed us to, and then another quick follow-up. When I read this finding of fact, I'm trying to think of the best way to ask this. Are you asking us to assign intent behind the finding of fact number 2, meaning it feels like you're implying that he was intentionally altering the record to protect himself, but that's not necessarily written in the finding of fact. Should we be allowed to make that inference about intent?
So the proposal for decision does include information about that. There was testimony about why that would have happened. So what we're asking you to acknowledge is that the impact of the record keeping appears to mislead a reader as to what was going on with that patient post-operatively. I'm not asking you to get into his intent, but to understand or to look at it from the understanding of a third party who would read that and assume that the record keeping was accurate when it was not.
May I say she did not find unprofessional conduct, which would be analogous to that, and that is found throughout the PFD.
Okay, I got another question that could be, and feel free to tell me that this is not reasonable. But there's a lot of findings of fact and conclusions of law here. I've scanned all of them. I think I've seen most of the ones that you're really wanting us to hone in on. But could you point us to the small number of specific findings of fact and conclusions of law that you want us to focus on that are found against, I would say, negative to the respondent? Because they're buried in here among a lot of things that aren't.
Sure.
And if that's not reasonable, then let me know.
Yeah. So I would say that the ones that I read, those are helpful ones to look at. Specifically for patient 1, look at 114, 116, 117. For patient 2.
I think it's fair to note the findings of fact that are positive in light of that, because that's what they're charged with.
Mr. Lecter.
So I'll tell you, Lewis, I'll tell you what, I'll let you point to things that you might think are helpful after Ms. Swanholm answers the question.
Sure, thank you. I just know I have limited time and I just wanted to, I apologize.
I'll let you answer that, but just also with limited time, but let Amy answer and then I'll point to what you want to point to.
Understood.
Sure. So for patient 2, 132 and 147 are helpful. For patient 3, 58, 61, 62, 63. I have to dig out patient 4. Give me one moment. Patient 4, 75, 76. '78 and 79. For patient 5, again, the one that we talked about, 92, 93, 94, 99. And I would also note that the way that judges structure the findings of fact and conclusions of law, the facts are a list of things that happened or didn't happen. And then the conclusions of law are the connection of those facts with the law, either to find a violation or to note that staff did not meet its burden of proof on that matter. So if you go to the conclusions of law, which begin again with new numbers, and that is on page 15 of our proposed final order. If you're looking at that, if you're looking at the PFD, it is going to be a little bit different because there were some exceptions filed by the judge. So it's probably better to look at the proposed final order, but they are substantially similar. For the conclusions of law, conclusion of law number 7 states that in failing to call an ambulance for patient 1, respondent failed to treat her according to the generally accepted standard of care, was negligent in performing medical services, failed to use proper diligence, and failed to safeguard against potential complications. This was a failure to meet the standard of care, a failure to practice in an acceptable manner consistent with public health and welfare, and then it cites to the rules, 4 different rules that were violated. In failing to call an ambulance for patient 1, respondent committed an act that violated state law and connected with the practice of medicine. This constituted unprofessional conduct. 9, in failing to disclose the risks and benefits of breast augmentation to patient 2, respondent failed to treat her according to the generally accepted standard of care, was negligent, failed to use proper diligence, and failed to disclose foreseeable side effects of a procedure or treatment, and failed to obtain informed consent. The judge also found unprofessional conduct for patient 2. Conclusion of law 11. In failing to participate in the care of patient 3 and 4 while they were hospitalized, respondent failed to treat patient 3 and 4 according to the standard of care, was also negligent, failed to use proper diligence. This was a violation of 3 different rules. 12. In failing to participate in the care of patients 3 and 4 while they were hospitalized, respondent committed an act that was connected to the practice of medicine, specifically unprofessional conduct. The respondent may be subject to disciplinary action for these. 14. Respondent failed to keep an accurate surgical record for patient 2's breast augmentation and failed to maintain complete and accurate postoperative records for patients 3, 4, and 5, and can be subject to discipline for that, citing to the medical record keeping rule. The judge does point out in 15, 16, and partially in 17 that there were things that board staff alleged that we did not meet our burden of proof on, and that's okay. Interestingly, that is somewhat consistent with the items that the peer review looked at and found that there were not issues that they were going to move forward on either. This is the result of expert testimony on both sides. It is a balanced report in that we didn't win everything, but we didn't lose everything. So just because staff didn't win everything doesn't mean that you should not take action. What it means is that there are issues here, but thank goodness it was not as egregious as we thought it might be initially before we got into the trial.
Thanks, Amy.
All right, Mr. Lecter.
Enumerating those is very helpful. Thank you.
All right, Mr. Lecter, go ahead. I'm going to give you that chance to also point to items that you think are helpful since we asked Amy to do that. So go ahead.
Well, thank you. Ms. Swano's comment is that, we have cited to items that are, helpful and indicative of this order that we recommend, which I still haven't heard why, is within the sanction guideline when actually
Louis, Listen,
Yeah.
hold on. I don't want to go ahead and go ahead and just list the items, okay?
Okay.
And then you can make an argument around that, especially if the board members have any questions, because I don't want
That's
to go
fine.
into.
I
all right.
get it. Findings of fact. Let's look at the findings of fact. Some of them seem out of place or out of turn, and you can go through them one by one. I don't find that necessary. I think we just need to look at them as like respondents. Let's just pick one. Let's go with 43 with patient 2. Respondent did not delay in addressing patient 2's healing problems. This is the one with the lost informed consent, which we maintain is with the American Board of Plastic Surgery, and this could happen to anybody. By the way, patient 2 followed respondent's suggestion that she seek wound care and had several visits at Memorial Hermann Clinic in February and early March. Her wound was debrided at Memorial Hermann as well. Neither respondent nor Memorial Hermann written informed consent forms for patient 2's debridement procedures. Respondent's medical records include photos of patient 2 that properly identified the patients in MIA's electronic record, which was something that the complaint alleged that, his records didn't maintain appropriate dates and notations. Look at patient 3. Number 49, respondent adequately documented his consultation with patient 3. Number 50, patient 3 obtained preoperative clearance from a personal physician. Respondent saw patient 3 for pre-op assessment after blah, blah, blah. Respondent assessed her as having a truncal and abdominal lipodystrophy and hypomastia. 52, respondent adequately documented his preoperative assessment. Why are they saying that? Because these were things that were alleged. Continues. Patient 3 returned to blank for her surgery. She signed forms, including informed consents, one for each for liposuction surgery, for abdominoplasty surgery, tummy tuck, for augmentation, mammoplasty, silicone-filled gel implants. Post-operative surgery, number 54. She was given post-operative instructions that clearly set out plans. 55. For her surgery, respondent wrote 3 operative reports, separately describing each of the 3 procedures performed. Blah, blah, blah. How much, and she cites what was done that was cited by staff that was inappropriate. 56, respondent's medical records for patient 3 include verified documentation entitled immediate pre-op evaluation, patient procedure identification verification, pre-anesthesia evaluation, preoperative report, anesthesia record, post-anesthesia record, each of which lists all 3 procedures performed during the February 24th surgery. Then 57, respondent's operative notes adequately document patient 3's procedures.
Hey, real quick, since I asked the question, I feel like I can jump in. Is it fair to say everything that Amy did not point out, you were pointing to?
Yes, she's
Okay,
pointing
that's
to
helpful.
stuff that is just the documentation portion of the issues, not relating to the primary care that was given to the patient in an effort to, I don't want to say misguide you, but not give you the complete picture.
Okay. All right. So, Amy,
The one question that remains is, where is this in the sanction guideline?
Okay, got it. So again, I just want to limit this to questions from the board members. So Amy, did you have anything specifically around Dr. Tibble's question?
Sure. And I just like to just provide a little bit of information about how judges are writing findings of fact. Is they're finding things that happened. It's not going to be that
Mr. Fresh Air, Mr. Carlton, do you want to deal with this?
Mr. Lecter, I will respect your time to talk. Please respect mine. A lot of the findings talk about generally what happened with the patient. I also do acknowledge that and we're not hiding the ball on this, that the complaint alleged issues related to the operative care, that his surgical notes, he had 3 separate notes for the 3 different procedures, even though they were not actually separate procedures. Our experts disagreed on that. The judge decided that that was not below the standard of care to have an operative note for a mommy makeover that was actually 3 separate operative notes, one for the lipo, one for the tummy tuck, and one for the breast augmentation, for example. They disagreed with our expert. That's okay. doesn't mean that there weren't other problems here. And that's what we're trying to highlight is that, yes, there were violations that were found. Of course, we acknowledge that we did not win everything that we alleged, and that's okay.
Okay. Dr. Jones, I know you had your hand up earlier. Did you have any questions still?
No, they were answered. Thank you.
All right. Are there any other questions by any of the board members? And I know Scott and Brent will help me if I don't see a hand that's raised. Okay. So this kind of goes now to deliberations. We can deliberate here openly, or if there's a desire to ask questions and seek guidance from our counsel, and remember that our counsel is different from Ms. Swanholm and others. Our general counsel are there to advise us directly, which is Mr. Freshour. So any board member can ask for us to go to executive session if they so desire to get advice from counsel, if there's that desire to do so. And if there is, please let me know. Otherwise, again, we can deliberate here. We can ask questions here. It's up to you as board members to ask what you would like to do. Brent?
Yeah, just as Mr. Freshour said before we began this discussion, once the period of deliberations is over, the board staff can choose to, the board can choose to dismiss. They can choose to accept the proposed order. They could make modifications to the order. So there's a lot of discretion that the board has in kind of how to proceed once you're ready to get to that point.
Yeah. Ms. Farmer, Dr. Farmer.
Good morning. This is just a comment for the new members. Just keeping in mind that once we've gotten to this point with physicians, that they've already gone through an ISC and they may have had an offer at that time. And at this point, sometimes the offer that was given at that point is not going to be the same once they go to SOA, and it actually may not be to the benefit of the doctor going to SOA as far as what the sanctions may end up being. So I just wanted to make sure that the new people understood that part.
Yeah. So since I think there's some questions, I think that require a little bit probably of advice from general counsel, I'm going to make the suggestion that we go into executive session and highlight those questions, because I know that this is the first time several members have gone through this process. And I want to make sure that the licensee has all the rights conferred to him or her. It's him in this instance, to make sure that they get their proper and appropriate due process when it comes to the sanctioning guidelines. So I think that's only fair to him, and it's fair to all of you who might have questions, who may be a little hesitant to ask it in an open forum right now. But that's what our general counsel is for. So I'm going to make that. I think that's a motion. Yes.
Second,
I'm making the motion
Barnes.
for us.
Second, Barnes.
Thank you, Ms. Barnes. And where is my?
Mr. Carlton,
Yes, sir.
if I may just say on the record, I don't think staff pointed to the sanction guideline portion that allowed the board to impose the recommendation that staff is proposing to the board today. And number two, I thank you for your comment, Ms. Farmer. I must say I did not quite understand what it meant.
It just means that
Well, Dr. Farmer,
Yeah, you need to answer.
It's noted, Mr. Lecter, that you're objecting to the sanctions.
Wasn't
There was a
objecting,
motion
I
on-
was saying I didn't understand.
Well, you did two things, but let me, Dr. Zafran, you've made a motion. It's been seconded. Vote
Yes.
on the motion and let's proceed at this point to see if your board wants to go into executive session.
So a motion has been made to go into executive session and it's been seconded. Is there any discussion on that motion specifically? Seeing none, all those in favor, please say aye.
Aye.
Those opposed? All right. So the board may close the meeting to the public and continue in executive session for the following reasons. In this instance, it is deliberations concerning disciplinary action, investigative information, peer review information, and possible rehabilitation orders under the authority of the Medical Practice Act, sections 152.009, 160.006 through 160.008, 164.007, and 165.202. Occupations Code. While in executive session, the board will not take any action, make any decisions, or vote with regard to any matter that may be considered or discussed. A certified agenda of any executive session will be made. It is now 9:18 a.m., October 18th, 2024.
Just one point of clarification. I know Mr. Lecter asked it earlier, but we'll ask it since we do have some new members right before we go into executive session. Are there any of our board members that are going to be recusing themselves from a vote on this case? Okay, thank you.
Okay, the executive session ended at 10:30 a.m. on October 18th, 2024. There was no final action, decision, or vote with regard to any matter considered or discussed in executive session. A certified agenda of the executive session was made. So before you board members is the proposal for decision, and you've heard both sides, and you've heard what the sanctions, proposed sanctions are by board staff. That is what is before you right now. I am going to go ahead and open it up for discussion on issues or concerns that you might have with these sanction guidelines, or for a motion on the sanction guidelines as they are right now. I think I'm going to go ahead and start with Dr. Tibbles.
Just real quick, Mr. Lecter, are you back on? We see your icon, but I know this is an important part of the discussion. I want to make sure you're able to hear us.
You should have mic and camera access now. Sorry about that.
Yep. Mr. Lecter?
Oh, okay, now you can hear me? Now
Yep,
you
we can hear
see
you.
me. Okay, thank you.
All right, thank you. All right.
All right. So as I had stated earlier, did you hear what I just said, Louis? Or
You said it was an important part, and
well, no. Before that, I said that we are now, as board members, here to discuss what is before us: the proposal for decision, the proposed sanction guidelines by staff. I understand that before we went into executive session, there were some concerns about what the sanctions were, along the idea of the sanction guidelines itself specifically. I'm going to open it up for either a motion on the proposed sanctions, or for discussion by the board members, questions and so forth. And again, I understand Dr. Tibbles had some questions or some concerns that he wanted to raise. Dr. Tibbles?
Yeah, and Dr. Zafran, before we do that, I think, go ahead. We came out of executive session at about 10:30, and there was no decision, vote, anything taken in executive decision, and they are now back out in open session. Mr. Lecter, pursuant to what Dr. Zafran just described, he's asked his board or the medical board if there's anything they want to talk about related to the PFD, the proposed final order, the sanctions, or to propose a motion, and I think he's now tendered a query to Dr. Tibbles.
Okay.
All right.
Thank you.
Thank you. So I want to hone in on one of the proposed sanctions, but just overall, I think that there maybe the overall feel is, for me, is maybe it's a little bit harsh, or what we find in the findings of fact and conclusion of law. But I want to kind of ask my surgeon colleague. I'm not a surgeon, so I've got a point of view, but I want to check it with my surgeon colleagues, which is the sanction around limiting the respondent to only practicing in a licensed hospital setting. I think I've got two thoughts about it. One is, from a practical standpoint, it feels like it may be putting him in a corner that is not winnable, knowing that the challenges with his board certification, and then now potentially with an agreed order, that getting credentialed may be a challenge, not of our creating, by the way, but just want to acknowledge the practical part of that. And then just from a patient care standpoint, to point out a lot of what he's doing is very, very appropriate to be done outside of a hospital setting, in ambulatory surgery centers, whether they're affiliated or not with a tertiary licensed hospital. So I think that there are kind of two reasons why I just want to hear a reaction from my surgeon colleagues to see if I'm thinking straight about that, and then maybe discuss ways to get what one may be. I'm thinking maybe the hope here is that the extra oversight in a licensed hospital around, having bylaws and quality standards and the option for peer review may be what they're getting at, and whether there may be other options like some sort of limited proctoring timeframe or something like that. But I'll be quiet and just love to hear a discussion from those that actually operate.
So I know we have a couple of surgeons here, Dr. Vanderweide, Dr. Bhatia. Do you guys want anything to comment?
Yeah, Louis, Dave Vanderweide. I have a couple of questions, and this may be to Dr. Charpu. Is he currently credentialed at a hospital?
No, because, he lost his board eligibility because this case has dragged on since 2001,
I get that.
21. The hospitals will not credential him. He's just unable to get hospital privileges.
Sure, but he was practicing prior to this issue, correct?
Yes, and there's been no patient death. There's been no,
I
horrendous
understand.
outcome.
I'm sorry, my question's a little more directed. Even before these issues, he had no hospital privileges.
No, he did.
He did?
Yes, he did. He had hospital privileges at St. David's and at Seton or Ascension. They've changed. And because of the issues and the complaints, we didn't renew.
I'm sorry. So he had hospital privileges and he allowed those to lapse.
Well, they wouldn't renew them. I specifically I actively worked in this. I talked to the general counsel, the lawyers that work for the hospital, that represented the credentials committee. And, we didn't want to take up a contested case hearing because that goes to a data bank issue.
Let's just leave it at that. Just so specifically, he's not credentialed right now to hospital. He was beforehand. Okay. David, anything else?
It's in the record.
Yeah,
Okay.
thanks, Wes. That's all I needed with regard to that. I do think that some modification in the orders is reasonable. Don't have any issue with the findings of fact or conclusions of law, but I'd like to suggest that we explore a proctoring by a physician approved by the board, another board certified plastic surgeon who is unaffiliated to the respondent, either by partnership or ownership. I'm thinking of 40 cases over the course of a year, perhaps 2 a quarter. And these need to be cases that are representative of the cases that have become at issue here. So whether that's a mommy makeover or a BBL or something that corresponds to the cases that have been brought into question here.
Is it okay if I say something?
No, not right now.
Okay.
Dr. Bhatia, did you have any comment?
My comments were basically, if I have the timeline correct, Mr. Lecter, this doctor came out of training and seems pretty quickly got into this predicament, right? Within what, first year or so, 2 years?
No, sir.
How long had he been out in training before this, out of training before this happened?
3 years. It depends how you define training. He's done several fellowships, and then he works in Miami.
When he finally came out to where he could start a practice.
Well, he worked in Miami without incident for several years, 2 years, 3 years, and then came to Texas.
Okay. So he had already had, he had finished his fellowship, went to Miami. Is that what you're saying? Worked there?
Yes, sir.
For 3 years?
2 or 3 years. Again, it's in the PFD and the body.
Then came to Houston or to Texas, and then within a couple of years there got into this predicament.
Yes, sir.
And
subsequent, we filed all the case logs. There's been, several thousand cases without issue.
And he's working. What's he doing now? How's he working?
He's working at a plastic surgery center named Mia Aesthetics. And, and my advice, we'd like to explore other opportunities, but given the complaint and the sanctions, it's difficult to do that. So, his hands are tied, both with board certification, eligibility, hospital privileges, let's
be very specific about the question. We don't want to get into this. Is mainly a discussion between the board members. If they're going to ask a question, let it just be a very, very succinct, like 2-second answer, and that's it. Otherwise, we're kind of get into, I'm going to have to let, board staff start answering also and all that. I want to just kind of really limit this. If there's a very specific question by board members to either attorney, let it just be very, very specific.
My last question
is, you keep mentioning he's not board eligible anymore. I don't necessarily believe that to be the case. There are, ways you can approach the board and ask for, a chance to complete board certification, even if it's not within the window. Have you all looked into that?
Yes, that's on the record too. We have a letter and we are appealing and submitting everything, but per the mandates, 2 seconds, he is not board eligible until ABPS says you have successfully appealed and gotten our attention and can submit case logs and.
No, I get that, but I just want to make sure that this panel knows that what you said has some truth to it. However, it's not the whole truth, because he does have a window or an alley to become board certified once this is resolved one way or another, correct?
It is the whole truth, because we got a letter pursuant to my contacting them and saying.
Okay, we're outside, stop. We're
It's in the
outside of the record.
I just
Okay,
want
he
to.
is he potentially board eligible if he wins his appeal, Louis? That's the
That's all I
question.
wanna
Period,
know.
yes or no?
That's all I want to know.
If he wins, he's board eligible, correct, Mr. Lecter?
He has the option to be.
I don't know how to answer that question. What kind of
Okay,
appeal?
then that's the answer. Thank you very much.
I mean,
All right.
potentially.
Any other
I don't have any-
questions
I
or
have no
comments?
other- no other
All right. Any other questions by any of the other board members or comments?
Well, I did have a follow-up question for Dr. Lecter,
Dave?
if you don't mind. When he
Go
was
ahead,
in
Dave.
Florida, was he in private practice?
No, he was working for the same employer, Dr. V.
Well, I mean, he wasn't in training. He was practicing plastic
No.
surgery.
No, he was practicing plastic surgery.
Okay.
Again, it's all on the record. Burn Fellowship.
All right.
I'm going to let Ms. Swanholm actually go ahead and answer part of that question too, because she has to have that opportunity also. Go ahead, Ms. Swanholm.
Okay, so board members, let me just direct you to where this information is summarized by the ALJ. If you go to page 34 of the proposal for decision, and that's the page within the document, it might be a different number within the actual document that's in there, but it's numbered as page 34, the bottom of the page. It discusses respondent's testimony at the hearing on the merits. It discusses his background. It discusses where he went to med school in St. George's. It discusses his applications and fellowships that he does complete. And then on page 36, it talks about that respondent began working at Mia Aesthetics, which is a surgical, a clinic that has multiple locations in Miami and other areas in the United States, as well as Austin. So he began working at the Miami location in 2018, worked there until the end of 2019. And then he relocated to work in Austin. He completed his plastic surgery residency in 2017 and was eligible at that time to sit for the exam. He did not do so until 2020. And then it goes on to summarize from there his testimony on the subject. So if you'd like to look at that, it begins on page 34 and proceeds to the beginning of page 37.
Thank you, Ms. Swanholm. Any other comments? Okay,
Yeah, I did have,
Ms. Barnes?
I did have a comment. This seems to be a pretty stiff set of elements for this order. Just thinking about, I think I heard there was a fine. I would ask that we consider maybe reducing that by half. I know there's some other elements from a read from the PDF. I think he probably be helpful to have some additional training. That will cost some money. Again, I'd like to not hinder the individual too much, but maybe even consider cutting that financial burden in half for him. And then coming up, and the reason we do these types of things is to modify the behavior and help people to remediate. It's not to be vindictive or punitive, although it may seem that way. But again, we do want to help protect the public and protect the individual, the respondent as well.
Okay. Any other comments?
I have one quick comment. Specific to the set
go
of
ahead.
CMEs, the the proposed 12 hours for supervision and delegation, I didn't see a clear component. And looking at this through the lens of an anesthesiologist with regard to supervision and delegation, I didn't see this as much as a supervision delegation issue, as more of a surgeon post-operative management issue. And so I think that we can kind of tune up the CMEs to kind of fit the situation a little bit better.
Okay, thank you, Dr. Jones. Any
Hey,
other
Sharif,
comments?
not to belabor the moment, and I don't have a
Yeah.
question, I do have a comment. Or I guess a question not to Louis. Just to be sure I'm clear, and I think there may be others here, can someone explain historically what, let me qualify this with an opening comment, which is what we see in the findings is that this respondent has rehabilitative potential. And it is our job to foster that. So in the spirit of that, if we do proctoring, can someone paint the picture for me and others? What does that look like? What are we getting in a proctoring situation? What is that doing for rehab? What is that doing to protect the public? Can someone give a brief description of what that looks like?
So I know that one of our board members, I think, has actually served as a proctor in some other capacity before. Dr. Deloche, do you want to maybe answer that?
Yes, Dr. Livingston. The proctoring that I performed was patient was the physician was practicing independent of me, no financial connections. I agreed and the board approved for me to review. I came up with in this particular case, 20 consecutive cases of major variety, not a carpal tunnel trigger finger type situation. And so what I performed is I showed up for their scheduled surgery, and I reviewed the history and physical, the reason why they're having the thought process behind why they're having the surgery, and then assisted, I guess, if you will. Sometimes I didn't scrub in, sometimes I did. But usually afterwards, we reviewed the case, how to go, and then just reviewed the post-operative orders. Now, in this particular case, since most of everything was after the surgery or hospital discharge, that would be something that I didn't do, but I did, we discussed the cases after I was completed. In this particular case, there was 20 major surgeries that we went over and reviewed the results. By the time I was done, it was either 3 or 4 months out that we were able to get everything accomplished. So that was in a nutshell what I did. And then I submitted a report to the board that my findings and my recommendations for that surgeon.
All right. Any other comments before I make a comment also?
Dr. Naidu.
Dr. Naidu, go ahead.
If we say that 40 cases, what type of cases? It could be trigger finger, it could be carpal tunnel. Probably it will be better within 1 year from the date of this entry, all the cases, rather than putting a number of the cases, or it could take 6 months, all the cases. Therefore, you can get variety of cases than minor cases of removing the moles or trigger fingers or carpal tunnel. That would be prudent proctoring.
Are you saying proctoring every case? Did I hear you right?
At least 6 months minimum.
Does that seem onerous to ask someone to basically shadow a surgeon, a busy surgeon, on all of their cases for 6 months? Feels like a full-time job. I don't know how that would be practical.
Or you can put some major cases rather than saying the cases. Define the major cases.
Yeah. So I think it's reasonable to put a timeline on this as opposed to a number of cases. I know that there is that this person does a very high volume, and that may be part of the issue. If you're doing more than what you can handle as far as managing numbers of cases and managing those patients appropriately. That may be part of the issue that's out there. Typically speaking, I'm not suggesting that we do any kind of chart monitoring as is being proposed, but if there's a suggestion that we do proctoring instead, then I think that there should at least be a certain amount of assurance that that the management of these patients, which I think is what's at issue here, especially postoperatively, is something that is being closely watched and monitored. I think the proctoring, can be delineated in a way to talk about large major cases, whatever that means, especially if it's similar to the cases that are being that these patients encountered, and not just every small little case that's out there. I think that could help limit the number that would be done. But I would actually propose a couple of years with the ability to come back 1 year later, like we've done with many other things. And if the person comes back to the board after a year and there's no issues, then at that point we can shorten that time period. I do think that the PACE course for medical record keeping is something that would be important. I do think that because PACE does not include specifically risk management, as was elucidated by Dr. Jones, I don't think supervision and delegation is important as far as CMEs, but I think 8 hours of risk management would be appropriate. I do think in all these cases that having the JP exam, understanding what our rules and regulations are, is key, especially since this is a person, I believe, who practices in other states also. I want to make sure that he is very cognizant of the rules that we have here in Texas, which may be different than Florida. But I think that would be important. I think a fine of $4,000 as opposed to $8,000, as was suggested by Ms. Barnes, may be appropriate. Now, and again, I think what I'm hearing were the things that I just outlined here, which I'm also presuming means not including the other things that were offered by board staff, which would be the chart monitoring and some of the other things also. Any other ideas or discussion or conversation that somebody wants to put forth?
Sharif, I'm really sorry to be perseverating on this. I think I heard you say that this guy may be doing 10 cases a day. Let's assume half of those are significant or major, would require proctoring.
Please read the record.
Hold on. I need someone to assure me that asking someone to proctor all of his major cases for 6 months is reasonable. To find a practicing board certified plastic surgeon to follow this guy around every day for half the day, and if it's reasonable, that's great. I just need someone to tell me, yes, that's reasonable.
I think you can talk about a certain number of cases in a given year or a certain number of cases in a given month, but I do think you have to have a time period.
Okay, I like that. I just don't think all major cases for 6 months feels doable. But I think if we put a number on it over a time frame or per month, I think that works.
Yeah, I think that Dr. Vanderweide may have suggested a certain number per quarter, but not just for one quarter. So if you're going to talk about maybe 20 cases a quarter or whatever that might be for a period of 2 years, but you can come back 1 year later, and if everything is fine, then we can limit that. But I do think that my personal opinion is, just having read through all this and kind of gone back and looked at the record, I think that this level of oversight is appropriate. I think that he's rehabilitatable, if that's the right word. But I would just be very cautious of belittling the things that were of concern here. There is a issue around how he selects his patients. And I do feel that what I see sometimes in cases like this is that it's almost like a, what's the word? Like when you have a factory and it's like just a conveyor belt, and it's just,
assembly line.
Yeah, like an assembly line type of thing, which is, it's not how we want to be treating our patients. They need to be treated individually and be dealt with as individual persons, as opposed to an assembly line. So I do think that having that level of oversight, again, maybe limiting the number of cases per quarter, but I do think it needs to be for a certain good period of time, with the ability to come back in a year and say, okay, I think you've exhibited the behavior that we feel is safe for our patients now, and we can bring it down as opposed to the other way around.
Got it. I totally agree with the length of time, sort of the longitudinal approach. Just was more focused on the practicality of the day-to-day. So I agree. I think the 2 years makes a lot of sense.
Yeah.
Dr. Vanderwide, did you have, again, a recommended length of time and number of cases per month or quarter, or however that should be broken up?
Yeah, I putting all this together, I think it's reasonable for a proctor to log 20 cases a quarter over the course of a year. We could set that for 2 years. The respondent can come back and ask for it to be wrapped early, depending on what the proctor's reports have been for the first year.
Okay.
And Mr. Carlton, I want to jump in here because if you're going down this road, board, Dr. Vanderwide, when you first talked about this, you named some specific procedures. And I think this is where Dr. Tibbles, this is part of your thing. I think Ms. Del Russell, I see you nodding your head. There were a couple different procedures you identified because it's not the whole world, because that's not practical. I think it needs to be focused on the issues. And I think somebody had said something, it's not the hand surgery, it's not the carpal tunnel. There's some very specific procedures. So that needs to be delineated. So if it's X number of these kinds of procedures over X number of time, that would be the kind of thing that these need to be tailored. Otherwise, there's not really a workable parameter, and you can't just say a major surgery. That doesn't mean anything to our compliance people or anything. You need to really kind of target what you're trying to protect your patients from and to help the physician with.
Sure. Well, let me go ahead and flesh that out a little bit better for you then. I started off with this, and I'll just wrap it up with this. I think that a proctor that is approved by the board, who is unaffiliated by either partnership or ownership with the respondent, should be arranged. I think that 20 cases per quarter for 2 years should be monitored by the proctor. I think that these cases should be representative of the cases that came up as part of this complaint. The Brazilian butt lift and the mommy makeover are the two that come to mind. So those are the cases that we want proctored. We don't need hand cases proctored. We don't need mole removals proctored. We need cases that are representative of the complaints here. And the respondent is welcome to return at a year, assuming that the proctoring reports are positive, and have the board take another look at the remaining year of proctoring and assess whether or not that's reasonable or not.
Okay, so that's one part with the proctoring. I heard also that there was a recommendation or suggestion for a PACE course for medical record keeping. And I heard that there was a suggestion for 8 hours of CME for risk management. And I heard there was a recommendation by somebody for the JP exam. And I heard a recommendation for a fine of $4,000 instead of $8,000. Were there any other recommendations beyond that? Or suggested recommendations? All right. Would somebody like to offer a motion with these proposed sanctions? And board staff can help. I know Mr. Palazzolo is sitting here, who can help with the language and help make sure that we're specifically asking for what we're thinking, so that we can get it out right.
I'll give this motion a shot. So yeah, maybe looking for some help to be sure I get all the suggestions. So I'll make a motion that we accept the findings of fact and conclusion of law, that we modify the proposed order, the sanction section of the proposed order to include one, proctoring as discussed, which would be 2 years, 20 cases per quarter, and cases representative of these complaints. And if I need to expand on that, let me know now. Does it capture it? And if we need specificity, we'll the Brazilian butt lift and mommy makeover,
yes,
for their respective components. 2, completion of the PACE course in medical record keeping. 8 hours of CME and risk management. and a fine of $4,000
Plus the JP exam.
plus JP exam. Did I miss anything?
Second, Barnes.
May I make a comment?
Oh, slow down. Just one at a time. Ms. Swanholm, you have a question for
Just
clarification?
a question for clarification on the PACE course. Are you wanting to include the PACE Plus coaching with that or just the CME?
No, this was the PACE Plus coaching.
Okay, gotcha.
Yes.
All right, Mr. Lecter.
Yes, when you specified pursuant to the complaint, do you mean the findings by the ALJ on the cases which had to do with postoperative care and not the actual surgeries?
No, I think we're talking about the full care, which includes the preoperative care, the intraoperative care, the postoperative care. This is the complete care. We're not going to parse this out.
Okay, because your expert testified that the selection
Mr.
was
Lecter,
above.
the board has made
Okay.
the motion. The
I'm
board
just
has made the
saying.
motion. The board has made the motion. We're done with discussion from you and Ms. Swanholm. This is with the board right now. The motion's been made. There's a second. Dr. Zafrian, call for your discussion. If
All right.
not, go to a vote.
So who made the motion? Dr.
I did.
Tibbles. Who seconded?
Barnes.
Ms. Barnes. Now, is there any further discussion on the motion before us?
Here's my discussion on the motion. Postoperative care cannot be decoupled from intraoperative and preoperative selection.
All right, thank you. Any
Second.
other discussion? All right. Okay, with that, is there any recusals? Let me just kind of ask that again. Okay, so all those in favor, please say aye.
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 All those opposed? Are there
Nay.
any Sorry, who said nay?
Nay, Morgan.
Okay, Ms. Morgan. Any abstentions? All right, so let the record reflect that it was all ayes except for Ms. Morgan was a nay and there were no abstentions. All right, that concludes the PFD. Okay. Moving on to the next item on the agenda is the Executive Director Report. Mr. Carlton.
Yes, thank you. And again, thank you, Ms. Swanholm and Mr. Lecter for a robust discussion on the PFD. We appreciate it and helping the board get to a resolution. I'll make this quick. I know that we've been in this discussion for a while. Again, I want to briefly just say thank you to all of the staff during my time away, the staff and the board for being so supportive. Things I feel like went well. We were able to keep the operations of the board moving. And we just have a fantastic team here. There are too many people for me to single out and name names. I know I forget somebody, but really this organization is fantastic. I really love being here, and I am so happy to be back as well. For the budget update, I will turn it over to Mr. Estrada, and then we'll continue on.
Thank you, Brent. Good morning, board members. I'll be brief. So fiscal year 2024, that closed in August, the end of August. Like I mentioned previously, we spent every penny for Fund 5105, Funds 5147, Fund 5105, and our capital budget. Any money left over in those accounts was rolled over for fiscal year 2025 and allocated as allowed by our GAA and statute. Our revenue collections for fiscal year 2024 increased by 4%. That's 1.6 million. That is the projections that we're using for our legislative appropriations request coming up for next session. And then for fiscal year 2025, I briefly mentioned this yesterday as well. We have less budget than we had for FY24, so we are going to be a little bit more conservative in our expenditures for this year until we can allocate some additional resources, or expenditures might come in at less than what we projected. But so far, we're projecting to have a balance of $3,000 left over for the fiscal year, and part of that is we are pushing to fill every position we can that we're authorized to have by statute, given that we are going into session with another large ask of FTE. So we want to demonstrate that we can fill those positions and we can retain them as best we can, that without salary implications, which seems to be a challenge that we have and other agencies have, and that'll be part of the messaging that we present with the legislators as well. So pending questions, I'll hand it back to you, Brent.
Great, thank you, Joey. And as part of the $3,000 balance, that includes how many board meetings?
I think in our last conversations, it included one board meeting, and that was only for the large board, not the smaller boards. Conversations last year were that the other boards would have their meetings during the summer. So by that time, we should have a better outlook and projection if we'll be able to continue to host those events. I think we can. We'll find some ways to move some money around. But I do know that for the big board, we want to host that in March as the earliest one. So we should have funding for that one set aside. And then as we get into June and August, we can see how funds are remaining for the rest of the fiscal year.
Right. So and to have one board meeting costs approximately how much?
It's about $1,500 per board member per board. So given that the larger board has more board members, that's usually around $20,000 if every board member came and stayed for the 2 or 3 nights and was requested the full per diem that they're allowed by statute.
Right. So the reason we get into that is we want to get back to having the full board being able to meet in person as well, but just trying to have expectation management as we go through this year. As Joey said, we have less funding this year than we had last year. And because of the legislative session and how they review our employee count, our FTE count, we want to make sure that we have all of our positions filled. We will have the board meeting in person in March. But around that time, we'll have a better idea of what our finances are looking like for having one in June or potentially August as we continue on through the year. Again, the goal is to have them. Joey is very good at managing our funds, but just as of today, that's what we're looking at is March for sure, and we'll work to try to have additional ones. Does the board have any other questions or comments?
Yeah, no, I guess the only thing I would say is that I know that the governor has always felt that it's important that we try to come back and meet in person. Our limitation initially, of course, was COVID, and we've gotten so good at doing things virtually now that it certainly helped when we didn't get our full funding a couple of sessions ago. So that was not anybody's fault over here. It's just that there were some limitations. But I do think it would be good for our request to the legislature, at least upcoming after that, is probably, we have 5 meetings a year. Right. I would guess that probably 2 meetings out of the year should probably be in person. And so even though we don't have that budgeted right now, I would think the board would probably like to see us have at least that budgeted for a couple of meetings a year. So.
Yeah, and there's definitely a lot of value to you guys being able to get together and being all in the same room, and people, especially our new board members that are just joining us for the first time today. And we have other new board members that have probably not had a chance to even make it to our new building. So we want to get everyone together. We just wanted to give the update. And when Joey was saying we're looking at getting to the end of the year with $3,000 left, it's going to be pretty tight as of right now.
Correct. Yes. Brent swiped all my contingency funds that I had squirreled away. So that is.
I took all the money. Yes. Okay. Dr. Deloche, I think you had your hand up.
Yes, sir. I was just on this budget. That's if all of the board members showed up. Now that we're post-COVID and we've been doing a lot of the virtual. So I guess is there anything in our rules or bylaws that we can be hybrid, I guess, from now on? And if that's the case, then maybe not all of our board will be showing up at the same time, eating up that $20,000 a meeting.
Yeah, right. There's not a requirement. I mean, we could theoretically keep operating like this indefinitely. But I know everyone does want to get together, at least have the opportunity to get together. And so we're going to try to do that. But yes, it is possible we get to the March board meeting and with people's kids doing spring break or other things like that, there may be a handful of board members that are not able to come in person, and that's fine. We'll find a way to make it work. We did kind of have a quasi kind of hybrid meeting, about a year ago or so. So it's doable. It's just the funding is a little bit more of a limitation, but we want to keep giving people and the public the opportunity to participate virtually. All right. For the legislative update, again, we are going into the 2025 session. Staff, as you've been briefed on, we have put forward our next legislative appropriations request and exceptional items. As Joey just mentioned, we are asking for additional staff, 60, right on, okay, remember 60 or 62, but yeah, 60 this time. We also are asking for a new system for us to do our licensing and to be able to get us into kind of one integrated system instead of multiple systems. It should make things easier for our applicants and also for our staff when going through the licensure process. So we're looking at a number of projects to make things better for our licensees, the public, for the staff. Obviously asking for additional funds. We're very appreciative of what the legislature has given over the last couple of years. There's been a 5% increase each of the last 2 years, but the amount of inflation that's incurred over the last few years has been very high. And so the amount that we've been given is helpful, but our analysis shows that we're still behind where it should be compared to the market. So continuing to ask for additional resources in that area as well.
And potentially compared to other agencies also, right?
Yes, we look at how we compare to other agencies across the state, other agencies in Article 8. So we do, Joey does and his team, a number of different analysis to see how we're kind of matching up to these other groups.
Yeah, and the reason I bring that up is because I know that we've lost some people to other agencies. And I think it's one thing if you're losing people to the private sector, but I certainly don't want to be losing people to other agencies, especially, if the limitations on how we pay is not then a matter of being a state agency, it's just being us making sure that we have the right compensation models that are out there. Because I think Ms. Barnes had said beforehand, the cost of hiring a new employee and training them up is significant also. And, having that retention, I think, is absolutely key.
Yeah, and Joey has done analysis on that, on what the cost is to bring in a new employee, to go through the entire hiring process, onboarding, training, and the amount of time it takes to get them spun up to be kind of, fully operational, to use a military term. But for our rule update, I'll hold off on that one until we get to that specific agenda item a little bit later. But again, trying to go quickly because I know it's already been kind of a long morning. So pending any other questions, that will complete my report.
All right. Great. Thank you, Brent. And again, welcome back. It's good to have you back. All right, Dr. Brett, Medical Director report.
Yes, good morning, everyone. I'll try to keep mine brief as well. DPRC did a fine job approving 14 new expert panelists, and those are there in the minutes for your review and potential approval as well. Glad to say that our changes in our processes have really alleviated some of the burdens that we've had in the past in our expert panelist pool. In fact, we're to the point where primary care practitioners were pretty much full on. So family practice, internal medicine, general pediatrics, who really don't have much of a problem getting those turned around. Where we're still having shortages, and for those new board members, I try to solicit suggestions from the board for recommendations for practicing physicians who would do well being an expert panelist for us. Oftentimes, the best recruitment are individuals that you all suggest or that you all are able to find and help us identify. So the specialties we could really use assistance on is oncology. There's a lot of conflict of interest out there with some big groups here in Texas and in the United States. So if you can help us find some oncologists, that's probably our largest area of backup. And then some of the subspecialists have been very difficult to locate, particularly in pediatrics. So pediatric gastroenterologists or cardiologists or virtually any of the pediatric subspecialties would be a big help. If you have anybody who's interested, I can forward some language on to you, or you can just send those names on to me and I can follow up directly with them.
Brent, I think, Robert, I think I sent you some information about a pediatric cardiologist and a pediatric ED physician already. So yesterday, so you should have a couple of names there too.
Yes, thank you very much for those.
All right, thank you, Robert. And as all of you know, and I've said this many, many times before, that we as a board are not the ones who determine standard of care. It's your peers out there who are practicing in that specialty, usually typically in other geographic locations, who are determining that standard of care. Now that does come to us as a board, and we make the final determination. But this is the opportunity for board certified licensees out in Texas to be part of this process. So it is designed to make sure that that standard of care is reflective of what is the community standard of care that is out there. So it is encouraged that licensees in our state be a part of that process. As we mentioned earlier, we have increased that compensation. It's still not the same as what you might be able to get in a private setting. It's $150 an hour for however long it takes to review a case or to do chart monitoring or whatever that might be. So again, it's just the opportunity for our licensees to be part of that process. And thank you, Robert, for helping in that. With that, I'm going to go to the public information update with Tori. Ms. Sloan.
Yeah, I'm here. Good morning, board members. Mainly this morning, I just want to welcome the new members and introduce myself. My name's Tori Sloan. I'm the Director of Government Affairs and Communications for the board. So my department plays a significant role in the communication with members of the legislature, communications with the public through our social media channels and our website. And we are also the primary contact for the media. That last bit is probably the most important point for the members. During your time with the board, you may be lucky enough to get questions from the media. If that's the case, please direct those folks to my office or to Mr. Carlson or even to Mr. Freshour in the general counsel's office, and we will be happy to take those inquiries off of your hands. That's all I have for you today. Dr. Zafran may have more insights on that. He's the one that usually gets hit up by all these media inquiries, but I'm available for any questions.
Yeah, just be mindful that if you get an email request, it happens fairly often from somebody from the media. Please go ahead and actually engage Tori. If you're in an area where it's convenient for you to be the person who is speaking on behalf of the board, remember that if you're speaking on behalf of the board, it needs to be coordinated with the board staff and with us. So please just forward all those inquiries. Same thing if you're getting questions, concerns from members of the legislature. Again, be careful in your private setting in what you say out there, and make sure that what you say is reflective of your own personal opinion, because it will easily be construed that you may be speaking on behalf of the board. So you just got to be very careful when you're making comments. Again, we've all had our Twitter accounts. We all have our LinkedIn, our Facebook, whatever it might be. But especially for our new board members, you're looked at in a little bit of a different way now. So whatever you say, even if you may say it feeling like you're saying it privately, will easily be looked at potentially as that you may be speaking on behalf of the board, and it may be taken that way. So I just put that out there as a word of caution, especially with things that may be controversial out there. Be careful of how that may look, how you respond in that kind of setting. So, Brent, do you want to add into that at all?
No, you covered it. I was going to mention, social media, those kind of things. And if, again, with the media requests, if someone cold calls you, they get your phone number somehow and you answer, just understand pretty much anything you say, there's really not really a such thing as off the record. So if you do make a comment to them, that may show up in an article somewhere.
All right, very good. With that, I'm going to go ahead and by the way, we'll get a lot more frequent updates, of course, as we get into the legislative session and between January and June. Tori, that's usually her busiest time. That's also the time that me and Brent will, in many instances, be asked to come and testify. I've already had to do that on September 18th, and we're always happy to do so. Again, it's more about explaining how something may potentially impact the board if implemented. It's not for us to give an opinion or to advocate for one position one way or the other. It's more about how would a ruling that is passed, how may it impact things? So the Interstate Medical Licensure Compact, for example, when that was being proposed, we were asked how that may impact us. And of course, we had to mention that it would require extra staff. It would require, potentially a process to make sure that that our processes were being followed appropriately. So it's that kind of engagement and that kind of answers that we typically help. We're not, again, advocating one way or the other when it comes to that. So, and if you guys have any questions, that's what Brent is here. You can always ask me. If I can't answer, if I shouldn't answer, I'll usually direct you to Scott. And that's what his role is for also. Okay, next item on the agenda is Physician Assistant Liaison. Ms. Gottschalk, are you there? Okay, so as all of you know, we have several other member boards with us under the medical board, the PA board, the surgical assistant board, acupuncture, MRT, RCP, and they are all, of course, an integral part of what we do. They do have their own individual board meetings. Whatever they pass eventually comes up to us to finally pass, but we all have that strong working relationship. Okay, next item 19, consideration and possible action regarding pending litigation. Scott?
Yes. Hello again, everyone. As you will find, I'm very soft-spoken and have no opinion, so you can. But in all seriousness, this report is just to give you an update. You, as the medical board, you take a lot of cases now. Like for today, for example, you just did a PDF for this physician. Sometimes those are appealed to state district court. If they're appealed to state district court, those come to my office. We get the attorney general to represent us and my staff, Wendy, Kamisha, Yvette, or Sarah, give them the background information. They're what we call a substantial evidence review. We win most of those because what the status of the law is on those is it said as long as there's a rational, reasonable basis for the board to make the decision, even if a lot of the record preponderates against what the board did, the court's going to uphold it. So the report I give you today is going to be, we've got a number of substantial evidence cases being appealed, which is not unusual. We're likely going to prevail on them. We do have a couple of cases that have gone up to the Texas Supreme Court. One's on a cease and desist order. There's some claims that we somehow are infringing on freedom of speech because the person's holding themselves out as a physician. Even though I have a medical degree, they don't have a medical license. They didn't do the proper clarifications. We have couple other cases going up through, but nothing that we really have anything to report on. These appeals many times take years. You will hear me at board meeting after board meeting. Still got this case at the Supreme Court. Still have this case at, federal district court. And we do have a few of those where they say we somehow violated federal law. But we have nothing of import to bring you today in that realm other than we have the normal substantial evidence cases. What I do want to do is take a moment and I want to reinforce what Dr. Zafran has said, what Brent has said, what Tori has said. If you get a media inquiry, let us know. Let Tori know, let Brent know, let myself know. If you get an inquiry from a legislator, always let Tori, myself, and Brent know. The other key is very important is if you're doing any communications concerning the board, use your TMB email. Because if you send a private email, say to another board member, and it's about board business, if you send something from your private email to the board, to my office, that potentially is all subject to open records request. And we have recently had a couple of, very innocuous, but basically private emails have to be produced in open records requests. So use your TMB account. Be very careful. Yes, you have private social media and LinkedIn and all of that. But if you put something up there that's board business related, that's going to be subject to open records as well. And I think Dr. Zafran's correct. You can say, I'm not saying this as a board member. I'm saying this as private citizen. I'm saying this as private citizen physician. But they're going to readily identify you as a board member. That disclaimer doesn't work very well. So just be very, very mindful of that. And you may occasionally get an inquiry from Sarah or Kamisha, and Kamisha's in charge of open records, saying, you know, dear board members, if you've had any communications about X, Y, and Z, or have you had any, please check your emails. And you can send back and say, no, I don't. If you do, you send it to us and we have to look at it. But again, what I want to emphasize is to be sure to use your TMB account for TMB related stuff. Now, the other thing I just want to point out is if when you're all assigned to ISCs and you have a question about procedure or content or the complaint itself, etc., you need to send those inquiries to me, Wendy, Sarah, Kamisha, or Yvette. Don't contact the staff attorney who's having the case, because they should not be talking to you about the evidence, the process, or the procedure. Be sure that's directed to my office or to whoever your hearings counsel is. And it's very important to remember that, because then we can address those kinds of issues. So that's kind of the breakdown we look at. And if you ever really do have process or procedure questions, like we've covered a lot of ground today, feel free to email me or any of the assistant general counsels and say, hey, Scott, or hey, you know, Yvette, we were sitting down today, or at DPRC yesterday and X, Y, and Z happened. I want to ask you about it. Or licensure. Go ahead and ask us about it. If you have a specific inquiry, and you'll get a lot of these, if you have a specific inquiry that comes in from a licensee or someone who has applied for a license, send that to Grace Unterborn, who's the director of licensure, but also send it to my office or to one of the general counsel, because we always see and work with Grace on that. So if somebody says, hey, you know, my application's been delayed for months, what in the world is going on? I want answers. Don't try to answer that. Send it to us. We'll answer those kind of inquiries. So again, we're a great resource. We can walk you through things. We'll answer questions, but be sure to utilize us. And with that, Dr. Zafran, thank you for the moment of privilege and just the opportunity to reinforce. And I think one of your members has her hand up.
My apologies.
Go ahead.
My apologies. Would it be, as a new board member, would it be appropriate that we get a list of the folks we should contact and what respectively we should contact? I did not know Taurine, for example, and I would agree. Great. I wouldn't know how to find her email. So
Lisa, you know, so what you're asking is appropriate, but if you ever have any question, call me.
Great.
Email me. I will, you know, I'll always be happy to direct you in the direction. Just don't ask me a specific question, because then it becomes communication that may be discoverable. And you know, so, but if you need to know who to contact about a certain case or certain issue, always feel free to contact me.
Or
Brent and Scott. I was going to say Brent and Scott are always your other good resource. And they're both always very readily available, both Brent and Scott. You know, a lot of times I will reach out to Scott and say, yeah, remember that Scott is your lawyer. Okay. Mm-hmm. He's your chief lawyer. So he is there to represent you. And in general, if you're going to communicate with Scott directly, that is going to be privileged information and confidential, because he is your lawyer. Mm-hmm. So if there's something that you're concerned about and worried about, whether you're asking the right question or the appropriate question, sometimes the safest person to ask is actually Scott, again, as your lawyer. So that's what I would suggest. But if it's something in general or basic, always feel free to reach out to me. Always happy to answer. The other thing I would just bring up, so be cognizant of the fact that, again, we are all public figures now. It took me a while to accept that. I had to go through the grief process and all that kind of stuff, but that's okay. But just from that standpoint, as a public figure, there are things that are going to be said about you. A lot of it may not be true. Just be careful about being baited into engaging in that kind of back and forth. It's not going to go anywhere good. And again, if there's any questions or concerns, always feel free to reach out to Scott. We deal with a lot of very controversial issues. That is part of our mandate. That is part of our job. Some people take that to changing it into personal attacks. They may try to bring out something about your past, something that may be out of context. Whatever that might be, it's always better to not respond, to not engage. If you're concerned that something is inappropriate, slanderous, whatever that might be, that's what Scott is there for. Those are actually the instances where you only want to communicate with Scott and nobody else. Especially for you new guys, just understand that it just kind of comes with the territory. Just don't get baited into it. A lot of times it's just, look at it. It's there, whatever it might be. But if you have any questions or concerns, talk to Scott about it. I don't know, Scott, if you want to add anything to that, but in the last couple of months, I know that a lot of board members have had those concerns, and I just want to make sure that everybody knows that it's out there and just let it go.
Yeah, I'm just, if you have any questions, any doubt, or not sure, send it to me. I've been around for 20 plus years. I know who to find, who to get it to, or probably I've seen it once before or something like it and can give you an answer.
Yep. Okay, moving on. Report on temporary suspension hearings. Now, these are all reports. These are all informational. So I'm going to kind of not go through them. I'm going to mention them on the agenda, but I'm not going to stop unless somebody wants to stop me and make a comment or ask a question about those reports specifically. So item number 20 is report on temporary suspension hearings. 21, there's none there. 22, there's none there. 23, report on cease and desist orders approved by the executive director. 24, report on automatic orders. 25, there's none there. 26, there's none there. 27, there's none there. 28 is discussion, recommendation, and possible action on the final annual internal audit, and this is something that is actionable. So, Brent?
Yes, thank you, Dr. Zaffron. Again, this is a requirement that we do an internal audit each year. We do them by fiscal year. And our partners that we have for this is Garza and Gonzalez and Associates. And so I believe that we do hopefully still have them with us. I know it's kind of been a long morning, so they can make their presentation. And then ultimately the board will need to vote to accept the report. And then we'll talk about what we're going to be doing for next, the current fiscal year and the upcoming report. Alicia, there we go. Hello. You can unmute yourself. Hello.
I am waiting for Kim Gonzalez. She's my boss and a partner of Garza Gonzalez. I am Chica Cherry. I work closely with a licensure director during the audit.
Great. So you need a few minutes still.
Yes,
okay.
I believe so. Please hold. Please bear with us.
Okay. Do you know about how much time you need? I mean, should we go to another item and come back?
I do see Kim logged in the meeting. Miss Lopez Gonzalez, if you can, you may need to toggle your camera and your microphone button so that we can see you.
Okay. Can you hear me now?
We can hear you. Yes, ma'am. Thank you.
Yes.
Okay, great. Okay, good morning, everyone. I'm Kim Lopez Gonzalez. Happy to be here this morning. And you've already met Chica Cherry. Chica is she was the one that really worked on this audit closely with the staff there at Medical Board. I would like to thank Alicia, Tori, and the licensing director, as well as one of the IT business analysts that worked closely with us, provided us all the information as we went through the audit. Before I get into the report that you have included in your board packet, I'd like to thank this board for appointing us this year as the Medical Board's internal auditors. This is the first year that we have come back to perform these services for the Medical Board, so happy to be back for fiscal year 2024. What you have before you included in your board packet is the annual internal audit report for fiscal year 2024. This annual report also includes the audit that was performed as part of that audit plan, which was the licensure area, which focused specifically on the licensure of full Texas medical licenses for the 9 months ended May 31st, 2024. This annual report also includes the status of our follow-up procedures performed for the fiscal year 2023, outstanding comments and recommendations that your predecessor auditor reported to you related to the enforcement audit that they performed. I don't plan to go into detail on this audit. It was a very positive audit. We did not have any comments and recommendations to share with you. We did perform a number of procedures to get to this point, and happy to report the positive outcome for the medical board. As far as the follow-up went, there were 3 outstanding comments related to that enforcement audit from fiscal year 2023. 2 of those comments were fully implemented, and 1 of them is incomplete but ongoing. And in addition to that, I know that the executive director did indicate that we are here to report to you the recommended audit for fiscal year 2025. I need to kind of step back a little bit. The fiscal year 2024 audit plan was prepared by staff during the time period before we were awarded the contract to perform the internal audit services. So as part of their risk assessment that they performed, that's how this licensure area came up. The next area that's part of that risk assessment would be the compliance monitoring area that was included in that plan. However, we usually do perform a risk assessment. It was just a very different year because of the timing when we were appointed as the internal auditors that we went ahead and went forward with the plan that was prepared by management and staff. But what we will do is kind of take a look at what was done for as part of that audit, see what has transpired as part of that risk assessment, and see what has transpired through fiscal year 25 to see if there has to be, if we would recommend any modifications, bring that to management and ultimately the board for approval for the fiscal year 2025. But as I indicated, if we were not to perform a risk assessment and we went forward with the one that was prepared by management, the compliance monitoring would be the next area to be audited for fiscal year 2025. And we would also prepare the internal audit report, annual internal audit report for fiscal year 25. This annual report is required to be submitted to the state auditor's office and other state agencies by November 1st to be compliant with those requirements. This annual report does meet the requirements required by the Internal Auditing Act. So upon your approval, this report will be submitted for compliance with those requirements. And with that, Chika and I are happy to answer any questions that you may have specifically on this report. Thank you.
Thank you for the overview of the FY24 report. I do have a question then for the FY25. Are you recommending to do the risk assessment and come back to the board in December for a decision on that one, or are you recommending we go forward with compliance at this time?
We have not, I guess that's what we needed to discuss with you and others, if that's the way that you want it to go forward with. We haven't had a chance to kind of see if there were any other agencies that have come in, any other entities that have come in to review any of the compliance area, or what other kind of area, what other areas may rise to a higher level. I don't know that we would be ready at that point in December, because that might take a little while. We may have to move it to your next meeting. So I will leave it up to you and your board to determine it and on how you would like us to move forward on that.
So I think, yeah, no, when we did ours, thank you for that. I just wanted to make sure when we did our analysis of this last year, it had been a while since compliance, I forget the exact year, but it had been a while since compliance had been looked at. And so I think as staff, we're still comfortable with compliance being up next, and then we can potentially look at doing that analysis for future years. I know Texas PHP is another one that's going to have to come up because it's due every 3 years. But as of right now, staff feels comfortable with that. And if you guys are okay with that, then I think that would be our recommendation to the board, is to accept the FY24 report and move forward with compliance for FY25.
Great. Thank you, Brent. With that, is there any questions from any of the board members specifically? And if there isn't, is there a recommendation or a motion?
I move
I
that
can
we
make-
accept the audit, the internal audit and the recommendations put forth.
Okay, there's been a
Dr.
motion by
Naidu,
Ms.
second.
Barnes, seconded by Dr. Naidu. Is there any further discussion? All those in favor, please say aye.
Aye.
All those
Aye.
opposed? All right, that's agenda item number 29. Thank you. Thanks for
Thank
hanging in there,
you.
guys.
Yeah, thank you so much. Normally, there's more findings and recommendations for us, so this one went really quickly as far as the report. But thank you so much for your team and for our licensure team and doing a great job. We appreciate it.
All right, so now we are to another part of our meeting today that is up for a little bit of discussion. I will hand it to Brent to kind of go through this a little bit more in detail.
Sure. Yep. Thank you. So we are getting towards the end of this rule review process. Where we are right now and the plan and recommendation for the board is it is currently out there in the register. So we are receiving comments. We are in the public comment period. It is only, it has to be a minimum of 30 days, but we'll continue to take comments like we normally do well past the 30 days up until the point that the board is going to eventually adopt new rules or put the rules back out with some type of substantive amendments to them for additional comments. Though what we're looking at right now is the other boards that Dr. Zafran mentioned before, the PA board, RCP, MRT, acupuncture board, as they meet between now and when you guys meet again in December, they are going to have their recommendation from staff to vote to recommend approval back to you guys for adoption of the rules that are currently out there with the proposed changes as we're doing this entire rule review process. So as of right now, there's not necessarily a vote that you guys need to make today, but we did want to give you that update. We have been receiving some comments, actually not a whole lot, but I think we'll probably get some more here in the public comment section a little bit later in the agenda. But overall, we have received a few comments on some things. One of the big ones had to do with OBA, office-based anesthesia. We did get a pretty robust amount of comments. They were all non-substantive. They all had to do a lot with definitions and things that just help clarify things more. It doesn't change the regulated community or what people necessarily have to do, but it makes the rules, I think, better rules than what we had initially put out there. Being that they're non-substantive, it would not require that the board have to approve the changes to go back out for additional public comments. But what the idea is, we will integrate those comments that have been submitted to us and send them out to you as the board members so you can see them and you can give us feedback on those and you can see the line by line changes of what's currently out there for public comment and what these new rules would be. Scott, was there anything you wanted to speak on about the OBA? I know we're not looking at necessarily adopting 100% of the comments that were submitted to us, but the vast majority of them look to be non-substantive and okay for potential adoption in December.
No, as Mr. Carlton was saying, I don't want to add a whole lot. I do want to, for the newer board members, what my office does is, as these comments come in that Mr. Carlton has just described, my office is charged with reviewing the comments and determining, if they're substantive, non-substantive changes. As Mr. Carlton said, they all appear to be non-substantive. If there's anywhere, and we do sometimes say, ideally we would like this regulation. Well, if it's something that we can't regulate or is beyond our authority, then my staff will look at it and say, when we get to the time to adopt it, say, we got comments from X, Y, and Z. However, board is recommending to decline to do those because we don't have the authority, or it's not a group regulated by the board or something like that. But we are required to do that summary when we get to the rule adoption actual phase. But again, we will be gathering, getting all of the comments. We'll be putting them in some kind of a spreadsheet where they're easy to read, but we will also be analyzing those for you in making determination as to whether or not it's something that can be done. But for the most part, and particularly with the office-based anesthesia rules, as Mr. Carlton was saying. They're just very, they're non-substantive because they're just further or more tightly defining the rules we had before. The one last thing I do want to mention on this is for the new board members, these rules are the culmination of a 2 or 2.5 year project. And one of the things that we strive to do is to create the rules where they flow logically. So everything about licensure, you find it in one rather big rule, but you find it. Everything about doing ISCs, you find it one rule. So we've tried to do those as operational areas of the agency, but the primary thing that we did was we put it in plain, simple language. We took it out a lot of jargon. What the prior rules had in them was sometimes pages upon pages of just taking the statute, copying it, pasting it, calling a rule. We've done away with that because the statute says what it says. The rules are just supposed to, for lack of a better term, implement the statute or fill out the areas that are missing in the statute or fill out the areas where the statute says the board shall write rules related to X, Y, and Z. But we've also made them very simple, plain language going forward. Thank you, Mr. Carlton.
Scott, I know there were some questions that came up around some of the things that we may have taken out in definitions that I know that there may have been some concerns about, not because of anything other than that it may just insinuate some other things. I think part of it was oversight over medical schools, for example. Did you guys look at that, and what was your thoughts on that?
Well, we've heard that comment is coming. We haven't seen a lot of comments yet, Dr. Zafran, and our timing is not quite syncing up with your board meeting here. But again, something like that, we did have a lot of rules that frankly were unnecessary or not necessarily something we could do. One was we had a rule that says, if you're a medical student, you have to be overseen by a physician. Well, yes, that's true, but we don't per se regulate medical schools. We don't regulate the curriculum. We don't regulate the rotations that medical students have. It's not like residency. One of the things I and you and I talked a little bit about, something along those lines, Dr. Zafran, is you could include that rule, but quite frankly, if there were a medical student came to sit and, came to a clinic, and I know they rotate out to clinics sometimes all over the city or where they may be, and the physician who was at that clinic or had the affiliation agreement said, medical student, go forth and, do all of these mole removals. I've got to go down the street to my other clinic, and something goes wrong. Well, quite frankly, the doctor's going to be on the hook, but we've also got a medical student that may be unlicensed practice. Now, the practicality of that is, in my 20 plus years, we've never had that complaint. Is it something really necessary? And I think the answer could be, well, we can put it in there, but quite frankly, if you turn a medical student loose, we're going to be knocking on your door as the physician. We're not going to be holding that medical student per se accountable for doing that. So there's some mechanisms built within the enforcement process under existing statutes that address some of those things.
Yeah, no, thanks, Scott. And I think that some of the concerns were really more around the clerkship years, like the third year, the fourth year, where they are, potentially doing these rotations. They may be, seeing patients, gathering data, making suggestions as to, part of their education as to how to manage these things. They may be scrubbed in surgeries, closing things. And I know that I've heard in many places that they may be, doing the final closure of a surgery, suturing the skin and so forth. And I think there was some concern that if that language was taken out, that it may have a negative insinuation, even though the practicality of it would not change things. So that it wasn't about regulating medical students while they're, taking their courses in their first 2 years. It was more around when they're actually out there actively learning and working directly on patients that there was some desire to make sure that we had that clarity there. So, and I'm sure we may be getting some comments around that.
Yeah,
so.
and again, as I said, we can do that. And of course, that also ties into, when you and I had this general discussion, that goes to supervision and delegation, because, training, experience, and knowledge, is it appropriate to delegate to them? It's not necessarily in violation of a statute, but again, this is a good time to remind everyone, when you look at supervision and delegation, it is not just by training, experience, and knowledge, and do you think you can safely delegate it? You can't do it in violation of any other state statute. So, you can't, you can delegate certain things to, say, a physician assistant, an APRN, or maybe even a medical assistant, a certified medical assistant. But you couldn't tell the certified medical assistant necessarily to go in and help you scrub in a surgery and do a wound closure or something of that nature. So again, those regulations, sometimes you're right, Dr. Zafran, the omission looks like it's opening the field, and that's not the intent. But again, that would not be substantive to the effect. It would still be directly regulating the physicians via what they were doing from a delegation standpoint. So again, those are the kind of things we will look at and consider during this ongoing comment period.
Yep. Good. And you board members will be receiving this. I know there were concerns about not getting necessarily these proposed rules in a timely fashion. I think the way we're doing it now is that it comes out to you guys about, a week beforehand, Scott?
Yeah, well, we Miss Yarborough and Liz, her assistant, Miss Quintero, they gave links when we put the rules up and ready to go to the register, that you and board members can see them and make comments as well. And we gave you a form and a link to do that. They're on our website, and they're also in the Texas Register. What we will do is, as we move along this process and we get the comments, they will be provided at the next board meeting for you to look at. We'll probably do it in a spreadsheet, likely Excel, and we will walk through the rationale and kind of our explanation in view of those things. And if you see any comments that are published that come in, you can always send a comment in. But again, that comes to my office, Yvette, Sarah, Wendy, Kamisha, that type of thing.
Yeah, no, I was kind of talking about like when we are looking at voting for these in December, that the final language that is put together that we're proposing is going to be presented to the board about a week beforehand so that they have a chance to review it. That's what I was talking about.
Oh, yes, sir. And I misunderstood. Yes. And we will do that. And what we may do is, for example, yes, we will give that language. If it is the same rule that you adopted for publication with no comments and no changes, we may refer back to that rule as opposed to writing the whole rule again, Dr. Zafran, in your inbox. But anything that we've revised, even with non-substantive amendments, we will publish so you can see it as board members, and we will highlight what's been added or revised. So it's 100% clear. And yes, we will get those to you at least a week ahead of time, if not a little bit sooner than that.
Great. Thanks, Scott. I'm trying to answer the questions I know that are being kind of thought out there because they've been asked before. So,
yeah, and again, because this is such a large project, as Scott mentioned, about over 2 years they've been working on, and it involves essential wholesale rewriting of even the numbering of the rules. It's going to be difficult to try to approve some rule changes and not other rule changes when we get to December because of the sequencing of things. So hopefully we're not in this position, but what we may get is that we may have a 90% solution to something in December. And if that's the case, there may still be a recommendation from staff to approve what we've got up to that point in time. And then you can essentially immediately restart any additional rulemaking process you need for any finer, kind of fine detail changes that come after that. But hopefully we get it all, and it's good for December.
Yeah, and to Brent's point, this is one of those things where you can't really approve. It'll be hard to approve one part without the other part because they are all kind of linked in this kind of rewrite. So this is not like a specific proposed rule change. It's going to be more of a wholesale thing. So to Brent's point and to Scott's point, it is going to be one of those things where we will need to look at approving it as a whole, and then we can go into very specifics after that. And if we need to address those specifics, whether it's adding or making modifications or whatever, to kind of do that as a separate thing after we actually get everything approved. So,
Yeah, and I will reiterate, Dr. Zafran, you've said this, should have started with this, as Dr. Zafran will tell you. Sometimes you have to adapt what's, as Brent just said, what's 90% good, but the rules are never in concrete. They can be constantly changed and updated as we see things we might have missed or as circumstances change. So when they're approved, that doesn't end them and it's like, oh, well, we can't do anything with them. No, you can rewrite them and you can modify them, you can amend them anytime. There's multiple steps in the process, but it can be done. The other thing is to be mindful that we're looking at having nice, clean, kind of pristine, if you will, rules ready and hopefully in place, because when the legislative session starts and once it ends, many times we're going to have requests and necessity to do some newer rules from the legislative session. So if we have a nice new set of good, streamlined, on-point rules, then the amount of change to be done after the leg session will also be minimized.
Yeah, great, thank you. Is there any questions from the board members as far as what we just talked about? I know we just kind of threw a lot at you there, so just want to make sure we kind of helped answer most of the questions I think you wanted to ask. But if there's anything else, just let me know.
Was one other thing, I don't know if we wanted to talk about the potential for advertising and board certification.
Yeah. So one of the questions that keeps on coming up is specific advertising for board certification. I know there's been questions from many sectors, including from legislators, around what our viewpoint is and what is it that we allow as far as a physician to advertise from the standpoint of being board certified, especially with different recertifying entities that are out there. The board has had the stance in the past that you have to be at least an entity that is an original certifying entity to begin with. In other words, that you have an exam process and a review process that does the initial certifying, and then if you recertify through that same organization, that we would accept that as somebody being able to advertise that they are board certified based on that process. Now, we have had a lot of other entities come to us who are recertifying agencies or recertifying entities, but they're basing their recertifying on an original certification from another entity. So I'll just give an example that, many people, many licensees get their original certification from something from the ABMS. The ABMS may be doing maintenance of certification to recertify. There are other entities that may come and say, we will recertify you, but we are relying on the fact that you were originally certified from ABMS. And what the board has said is that you have to be an original certifying entity as well as recertifying in order for you to be able to qualify. Now, based on that, we have looked at original certifying entities that are out there, including ABMS, but I believe, Scott, there's 14 others that are also qualified to be original certifying entities. So it's not just ABMS. There's many, many other entities that have qualified to be original certifying entities where we allow a licensee to advertise they are board certified based on that. So it's certainly not just ABMS. They are, if you want to, for lack of a better term, the gold standard. But there are others who have come to us and have qualified to be an original certifying entity. Where the rub has come in is these other agencies or other entities that are recertifying entities that want to use somebody else as their original certifying entity, and we have typically not approved those. And I know that there's been a lot of questions and concerns and, for lack of a better word, objections to us doing that. But that is our current process. That is our current rule. That is what we are following. We have already told these entities, I think some of them are, I believe, well, not getting into specifics, but they have come to us objecting to the fact that we have not looked at them as being somebody that could be used as somebody that a physician can rely on to advertise that they are board certified. Now there have been some suggestions in our rulemaking to take away any reference to ABMS or any specific entity out there as an original certifying entity, and just put in the definition of what we believe is an original certifying entity. And that again is part of the comments that are out there. So Scott, I hope I kind of helped elucidate that and hopefully didn't confuse it anymore, but that's the general gist of that.
No, I think that's fine. And I don't know if Mr. Carlton, you want to add anything, but yeah, we have those comments and we are going to be looking at this is the looking at these during the rule review process, if you indicated, Dr. Zafran.
Yeah, again, the board is interested in making sure the public is not misled and they're getting correct information in advertising that someone is board certified. And for the board, for the medical board's purposes, that means you are currently certified by the certifying entity that you claim to have the certification from, not that you had been certified 10 years ago and you've allowed that to lapse for whatever reason, but still claiming that you're board certified when you're no longer currently board certified. Because these, as you know, these entities have where you can look up the licensee. And so if you go and someone claims that they have a board certification from ABMS and the patient goes and types in that physician's name and it doesn't come up, well, then they're going to start asking questions about why is this person saying they have board certification when they currently do not. And about the maintenance certification, this does come up from time to time. That is not a requirement of the medical board. In our rules, we do not require maintenance certification. We do not require that the certifying entities have any type of retesting or maintenance certification. For us, we're indifferent whether it's just a one-time certification that lasts for life or it's something that has to be redone periodically. But we just want to make sure they are the original independent verifier of the individual's qualifications and that they are still currently certified with that organization.
Yeah, and also it is not a requirement actually by law. Facilities cannot require that somebody maintain their certification or have a maintenance of certification unless the medical staff of that facility votes to make that a requirement. And I know that's a nuance that keeps on coming up, but that law was passed many, many years ago that states that hospitals cannot make that a requirement of credentialing unless the medical staff makes it a requirement of credentialing. That requirement has to come from the medical staff itself. So, all right. Anyway, and unless there's any other questions, I will move on. So right now we're going to come up to item number 36, which is we're open for public comment, and it is certainly past 8:30 a.m. So I'll hand it off back to Brent to manage that process.
Thank you, Dr. Zafran. And items 30 through 35, there was nothing else to discuss. For agenda item number 36, this is the portion of the meeting where members of the public can make comments to the board. They can have up to 3 minutes to make those comments. Usually it's something that they want to make the board aware of, potentially something they want them to consider for a future agenda and a future meeting to be put on the agenda. The board does have to be careful in whatever type of discussion is going on. Usually you're limited to just answering factual information. It may be when's the next board meeting, how many board members do you have, something like that. But anything that's kind of a substantive discussion or any kind of robust debate on things, generally we want to stay away from because it's not something that's on the agenda that it gave the rest of the state and the public a notification that this was something that was going to be discussed today. So we do have, I believe, up to 3 individuals, I think I saw the names, that would like to speak today. And so in any particular order, if you would like to make a comment, if you're online, please just go ahead and raise your hand if you can. If not, if you don't have that function or can't find it, just go ahead and unmute yourself and state your name, and we'll get you started with your 3 minutes.
Hello, everybody. Can you hear me?
Yes, we can. Please just go ahead and state your name and who you're with, and the floor is yours.
Okay, my name is Carl Bonnet. I am with a company called Clarisana. I'm a Texas licensed physician. I appreciate your time today, and I apologize for being at the airport today, so if we have any overhead noise. To be quick, I just want to make a quick comment related to the proposed new chapter 192 regarding office-based anesthesia. Raise a few points for your all's consideration. So again, I said my name is Carl Bonnet. I'm an emergency physician by training, have 20 years of experience, also retired from the Army National Guard, had several deployments to the Middle East, and have a fair amount of experience with ketamine in both procedural sedation context and in an austere combat environment as well. I own 2 clinics in Texas where we provide psychotropic ketamine therapy, so sub-anesthetic ketamine therapy. And I just want to bring up a few points for consideration regarding the proposed new chapter. There's some confusion in the field of psychotropic ketamine therapy as to how the office-based anesthesia rules relate to what we are doing, which is sub-anesthetic. Our patients are not being anesthetized. We are not having them lose consciousness. Back in 2017, myself and Dr. Sanjay Prasad, who also will be presenting, I believe, here today, had complaints made against us to the Texas Medical Board saying that we should have registered for office-based anesthesia. At that time, we both successfully argued to this body that we are not, in fact, performing office-based anesthesia, that we are performing psychotropic ketamine therapy, which is sub-anesthetic. So those cases were both dropped. And since that time, we've been operating our clinics under the assumption that it is not office-based anesthesia. My concern with the new chapter is especially section 13. There's a little bit of confusion where it talks about ketamine being able to use induce unconsciousness. We are not doing that. What I would respectfully propose to this body is, given that there is a large explosion of clinics providing psychotropic ketamine therapy, there's a large growing industry of home ketamine, mail order ketamine clinics, which are basically sending oral ketamine and auto injectors of ketamine to people's homes, not being performed in clinics. I would again respectfully submit to the TMB that they should get involved and perhaps create a new chapter called psychotropic ketamine therapy that addresses the mental health use of ketamine, which is fundamentally different than the anesthetic use of ketamine. I think this field has been growing dramatically, and the TMB, again, no disrespect to anybody, has not overtly been involved in that process. And I think it really is, the therapy is tremendously beneficial to our patients, but I do believe the TMB should be involved in that. So I will turn the floor back over to y'all, and I appreciate your time. Thank you very much.
Yeah, thank you for your comments. This is Dr. Zafran, and let me just kind of address some of those things that were said. So first of all, it's very clear in Texas that things do not have to be FDA approved for a drug to be used for a certain other type of indication. Licensees are able to use medications for other indications, such as with ketamine. I understand that there are uses out there for chronic depression. There are uses out there for chronic pain, and again, that's fine. But until the FDA makes a determination that ketamine is not an anesthetic drug, we are kind of bound by looking at it as an anesthetic drug. There is not a definition out there of a sub-anesthetic dose. Propofol is another anesthetic agent. There's an induction dose of propofol that is very clearly delineated. It's like about 2 milligrams per kilo. But if I take a sleep apnea patient, I can give them 10 milligrams of propofol, and that may completely make them stop breathing. There are other patients out there where I may give them 300 milligrams of propofol, and they're staring at you and saying, when am I going to get my medication? The point being is that these anesthetic drugs are very dangerous drugs that are not reversible as far as them stopping a patient from breathing. Fentanyl, I know that can be given in anesthetic doses, but it's reversible with naloxone. Benzodiazepines given in large doses can also be anesthetic agents, but they are reversible with Romazepam or flumazenil. But anesthetic agents like etomidate, propofol, ketamine, many agents like that are anesthetic agents that if a patient goes into a deep sedation or into general anesthesia, the only way to manage that patient, because you can't reverse the drug, is to manage the airway, which means that you have to have the knowledge, the ability, and to be able to, and the equipment to be able to manage that airway. And that is the stance that the board is taking. Now, we have mechanisms to address places where anesthetic drugs are given outside of a hospital or a licensed facility. And that's where the office-based anesthesia rules have come in, because if you're in a licensed facility like an ambulatory surgery center or in a hospital facility, those criteria are already present and available. But in an office-based setting where you may be giving these agents, there are going to be requirements for making sure that it's not just about ACLS. You don't want to wait until a patient codes until you're showcasing that you have the knowledge to resuscitate that person, but it's about managing the airway specifically, making sure that you can intubate that patient, that you can ventilate that patient if necessary, that if you're going to give a drug that is going to paralyze that patient because they're in deep sedation, that you have the reversal agents to deal with somebody that may have malignant hyperthermia. All these things are very specific to these kind of scenarios. And as I just very clearly stated, there is no definition out there of a sub-anesthetic dose. I understand that that folks have tried to argue that I'm giving a sub-anesthetic dose. I don't know what that means. We do know that there have been instances around the country where ketamine has been given in EMS types of situations where sentinel outcomes have happened. And those patients have had a sentinel event. Many instances, they may have died. So these are not simple drugs. I understand, again, that they're being used for psychotropic needs or for chronic pain or whatever. That does not make them any less dangerous. And we also know that there are many drugs out there that haven't even been approved yet or out there that may also have the same impact. And I believe some of the proposed rules would cover the wide basis of what those drugs may do, and future anesthetic drugs that may have other indications at some point. The fact that they're being done in many clinics out there, that does not make it right, or does not mean that it's not being appropriately overseen. Sometimes the rules have to catch up with what proposed models of delivery that are going on out there. So just because they've been happening for a long time doesn't make it right. Michael Jackson was getting propofol in an inappropriate setting for a period of time. That didn't make it right. In fact, that physician was convicted of murder afterwards. So just because it's happening doesn't mean that it's right. What we're doing right now is trying to make sure that the rules catch up with what's going on out there. That's why it's out there for public comment. All those comments we welcome and we will continue to look at. But that's the reasoning of the board so far. All right. Sorry. Back to you, Brent.
Yeah, thank you, Dr. Zafran, and thank you, Doctor, for your comments. I know you guys did also submit some material for the board. Is that correct?
Yeah, yes, we did.
Yeah, okay, and that is in the board members' folders in the public comment there. So it is available. Looks like it does have some research and some articles in there for the board to consider. Something that could be helpful for us as well is if you do have any proposed language that you would like to see as far as a rule, that would be very helpful for us to see something in writing and try to kind of go through it that way. And see if there is some way to incorporate that, or if ultimately if the board is not ready to go in that direction yet, but at least that could be very helpful in making a decision.
Yes, if I may just clarify, I'm not in any way trying to skirt the board's rules. I am simply proposing that perhaps a new chapter be created that does include the appropriate monitoring that Dr. Zafran has mentioned, but also includes the appropriate psychological monitoring that patients should have as well. So that's just to clarify my intent.
And that's a very important point to make. And as Mr. Carlton said earlier, these rules may go 90% of the way to at least make sure that we are getting what we need to get, at least for right now. But there is definitely going to be an opportunity, and of course that opportunity still exists right now. Don't let me discourage that. But even if we don't incorporate that now in December, there will be opportunities to make those suggestions. It may mean that we have to put a stakeholder meeting together to get all those involved and come up with something that may be a little bit more robust that takes a lot of that stuff into account. So this does not discount what you're talking about, which I think has a lot of potential value in it. So even if that doesn't happen now, we still want to make sure that you guys are involved and engaged in possibly putting something like that together.
Great. Thank you for your time, sir.
Absolutely. And again, thank you for your service. Appreciate it. All right. I think, do we have a Dr. Prashad also?
Yes, hi, good afternoon.
Hi, how are you?
Good, how are you?
Doing great. Yeah, please just go ahead and state your name and who you're with, and the floor is yours.
Sorry, it seems like my camera is going out here. Okay, well, good afternoon, everyone. Dr. Zafran and the members of the board, thank you so much for taking the time to listen to us today. My name is Dr. Sandhya Prashad. I'm a board certified psychiatrist specializing in interventional psychiatry. I have a private practice here in Houston, Texas. And I am the president of the American Society of Ketamine Physicians. It's a nonprofit organization formed in 2016. It's multidisciplinary that has worked to create some guardrails around this treatment in a multidisciplinary fashion with specialists from different fields. To echo some of Carl's comments, specifically, I think our concerns are around not having the psychological monitoring. A lot of these patients are suicidal and not including those sorts of things in the particular rules that we're looking at. And then also just this really booming online industry. So sending injectables to patients at home. Some of these companies are sending doses that are higher than what we even give in clinic. And so there's a lot of ambiguity. There's even companies that are sending ketamine directly to patients for them to administer to themselves in their therapist's office, and their therapist is taking their blood pressures and reporting it back to the company. And those really, I think I'm very, very concerned about those kind of cases, that's essentially practicing medicine without a license. And so these rules don't capture those sorts of scenarios. And that's where we would really value the opportunity to engage in a dialogue with you all about how we can create something that really does capture this industry. So there's we will be submitting some formal comments that we've put together with a group of various individuals, and hope we can continue to engage in conversation about that. But just very concerned that this is a great opportunity and a really critical moment for us to help establish the right kind of guardrails. And we agree, Dr. Zafran, that the monitoring that is already outlined by OBA, a lot of those things are critical as well. I think we're just saying that we need some more in addition, and that there's just a lot of ambiguity in this space, and we'd like to create more clarity.
Well, great. Thank you. We appreciate you being here and your comments. And again, we look forward to getting those comments from you, and your written comments, and also any proposed rule language you have. Whether it be an entirely new chapter, that would be great, and something for us to review. And we look forward to working with you further. And as Dr. Zafran said, and I think as Scott said earlier when talking about the rules, for something like this, it'll probably end up being going to a stakeholder group, or we'll have a lot of interested parties come and provide input. But if we do have a baseline of rules to go off of, that can help move the process along much quicker. So thank you. Evan, is there an Evan here that was going to talk, or no? Okay, all right. Well, thank you for being here, though. All right. All right. There's no one else here in the room with us for the public. Is there anyone that is on Teams or has dialed in to the phone number that would like to make comments to the board?
Just a reminder that if you did dial in via phone, you'll need to click *6 in order to unmute.
All right, we'll give it another few seconds. Again, if you can't raise your hand or if you're doing that, just go ahead and state your name. Okay, not hearing anything else. I think that will complete agenda item number 36.
All right, great. Thank you, Brent. 37, discussion, recommendation, possible action relating to personnel matters. There are none there. With that, I will move to the consent agenda. I'm presuming we're ready for the consent agenda. All right.
It is ready. I think just real quick, when we get to that, Dr. Quinones, you did have something you wanted to bring. Okay, so
yes, I do.
Okay, go ahead.
I'd like to make a motion to accept the consent agenda with one modification. Brent and Scott, if you could help me make sure I do this correctly. I want to modify a order that I dismissed, or a item that I dismissed, 24-0556. I dismissed it with instructions to refer to TPHP, and I'd like to modify that to just a straight dismissal.
That's fine, Dr. Quinones, and this is the consent agenda for DPRC, correct, sir?
Yep. Correct.
So you've made a motion
Second,
to accept. Okay.
Great. All right. So there was a motion and a second. Any further discussion?
All right. So with that motion, and I'm presuming that, Scott, can I include everything else, or do we need to do this specifically by itself first?
Do this one separately because of the amendment, Dr. Zafran. It would be much cleaner.
And I have a brief motion as well for my something from yesterday from the DPRC.
All right. So just
let's do this one first, and we'll come to you, Dr. Jones.
Just letting you
know.
Yep.
Thank you.
Yeah. Hold on. I want to be sure. So, Dr. Jones, when you say you have an amendment from DPRC yesterday, is this on an action taken, or what is this? Because we'll need to do it all, because we can't adopt the consent agenda and then have Dr. Jones do an amendment to the same consent agenda. So we have one proposed amendment right now. We've got a second. Instead of taking the vote, Dr. Zafran, I think Dr. Jones may have something as well for the consent agenda.
I do. On one of the cases from yesterday at the DPRC, which I need to pull the number, we voted to send it back to an ISC.
Mm-hmm.
That case actually contains two separate patients. However, my issue was only with one of the two patients within the ISC that we voted on to reject the dismissal and send back. So I'm trying to parse out. There was.
Do we
one
need to? Is that something that we really need to delineate here, Scott? I don't think so.
I'm happy to. Okay.
No.
Yeah. No. I don't think we need. Yeah.
Okay. Then I rescind that.
Okay.
Okay.
So now you can take your vote, Dr. Zafran.
All right. So there's been a motion, has been seconded by Ms. Barnes. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? All right, that passes. So with that, now we're going to go to the full consent agenda. Consideration approval of August 16, 2024 medical board minutes and action items, committee reports, and consideration approval of minutes and action items of committee meetings during the board meeting.
It's Dr. Quinones, motion to approve the consent agenda as outlined.
Got a motion from Dr. Quinones. Is there a second?
Second, Stefano.
All right, it's been seconded by, I believe, by Naidu. Any further discussion? All those in favor, please say aye.
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 All those opposed? All right, motion passes. Now, I will entertain a motion to adjourn.
Motion to adjourn, Vanderwine.
Second, Biden.
All right, so we've got a motion and a seconded. Any discussion? All those in favor, please say aye.
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 All right, we are concluded at 12:22 p.m., 10/18/2024. And all I'll say before this is over is hook 'em horns.